May I have your lordship kindly?
Original side.
Yes.
May I have your lordship kindly?
Take the appellate side matter for modification only, my lord. Not now. But next. May I try my luck on Friday? No.
May I mention, your lordship?
Mention a matter for inclusion, undefended suit.
Undefended suit. Month of February.
Lordship, may I mention, my lord, in this suit there is a direction.
Mention in the month of February.
In this suit, my lord, there are directions for examination of the plaintiff's petition on commission, my lord. Now, what has happened, my lord, we are unable to proceed with the commission because the court has misplaced the exhibit file, my lord. There was a stay in the suit for a year because matter was there in the Supreme Court. Now it's to restart, my lord. For 1 month, my lord, we are going following with the department, my lord. It's not happening, my lord. If the matter can come up as to be mentioned, my lord, this issue can be sorted out, my lord.
Mention after December.
My lord, but the commission has to will expand in 11th of December, my lord. If it don't come at to be mentioned, my lord, a formal direction will help us, my lord.
To be mentioned first, 2nd December.
May I have your lordship's kind leave?
देखिए फाइलটা দাও। Yes. আমার খাতাটা কোথায় গেল? নোট খাতাটা বাঁধানো না, নেই তো বাঁধানো, ওটা হারিয়ে না যায়, ওটা আমার এগুলো সব এখানে দিয়ে দেবে বাবা।
May I have your lordship's kind leave?
Yes.
To mention a suit. In the suit, we filed an application for ad interim relief. Ad interim order made directing the defendant to keep money apart in a separate bank account. Not complied, contempt filed. In contempt, they've deposited the money with the registrar original side. In the meantime, they took out an application for acceptance of their written statement, which has been dismissed by holding that it's beyond time. Now, my lord,
It's by me.
No, by your lordship. The application on which the ad interim order was passed also has a prayer for
What do you
judgment.
want?
I want inclusion, my lord, of the suit along with the pending GA for judgment upon admission. The suit will have to be
Judgment upon admission, affidavits
completed and suit now undefended.
It will appear undefended. It will appear afterwards.
But the GA,
The GA may appear in the monthly list of December. Adjourn motion.
Obliged, my lord.
Adjourn motion.
Yes, GA1 লিখে দিন। GA1 হবে।
GA টা থাকবে adjourn motion. Adjourn motion. Yes.
Lordship, may I be permitted to mention one matter?
Take the microphone. Yes.
Lordship, I am for the plaintiff petitioner. In this suit, my lord, we have taken an application called ACOM 3 for striking out pleadings of the defendant number 2 in the for striking under order 6 rule 16. In the last occasion by the Honorable Predecessor Court, it was directed that the defendant number 2 would file their opposition. But till date, they have not filed the same. By the predecessor Honorable Court,
All right, mention after December.
Lordship, the returnable date was on 27th November.
All right, no problem. Next.
Lordship, my request is just to ensure that the date remains the same, my lord.
All right, it will be seen. Next. Presentation of plaintiff.
Lordship, may I hand over the mentioning slip?
Afterwards, mention after month of December.
I appear for the plaintiff, my lord, suit for recovery of the price of the goods sold and delivered. My lord, the plaintiff is carrying on business within jurisdiction. The defendant, my lord, is outside jurisdiction. If your lordship, my lord, kindly comes to, my lord, paragraph 1 of the plaint.
Order to rule 2.
Order to rule 2, my lord. And, my lord, leave on the
Price
clause
of
12.
goods sold and delivered. Why order to rule 2?
Lord, just in case, my lord, it is leave under clause 12, my lord, and order.
No, leave under clause 12, I understand. But why order to rule 2? Price of goods sold and delivered, you know what is the price.
My
So why order 2 rule
My
2?
lord, your lordship may not grant that, my lord. Only leave under clause 12.
What is the cause of action within?
Within, my lord, the work orders were placed within, goods were delivered from within, and the, my lord, bills invoices contained, my
Delivered
lord.
from within. Okay, plaintiff delivered.
Yes. And
All
my
right.
lord, page 43, annexure C would indicate.
All
my
right, Ashun. No, but section 12A dispensation.
Yes, my lord, premediation we have exhausted.
Show me the non-starter report.
My lord, your lordship would kindly, my lord, may I indicate
Show me the non-starter report.
report, my lord. My lord, the non-starter report is yet to come. The application I have annexed.
Come after the non-starter report comes. You have to disclose it in the plaint.
My lord, it is disclosed, my lord. I have
Show me that non-starter report.
The non-starter report, my lord, I have only indicated to the extent.
Your
My lord,
indication will not do unless you file a non-starter report. Come up with a non-starter report then.
My lord.
Ashun. Since the non-starter report showing that the parties have, that the pre-litigation mediation has failed is not available on the plaint. The presentation of plaint stands adjourned and the same shall be taken up after the plaintiff files the non-starter report. Poster. The same can be presented. Same shall be presented after the plaintiff discloses the non-starter report by way of a supplementary affidavit.
Obliged. Item number 3 and 4.
My lord, this has come at my instance. I appear for the defendants in these suits, my lord. The mandate of the commissioner has to be extended. It
When is it going to expire?
expires on 28th of November. 28th?
Expired?
No, 28th
Will
of
it?
November.
Oh,
Will.
28th it will expire.
But I appear for the plaintiff. My only prayer is your lordship will fix a peremptory date because this is the 5th extension. We finished our chief in February last year. It's about to be 2 years.
My lord, the difficulty is that
It's everyone's difficulty. There are so many parties, but if your lordship fixes it, some sort of direction be given that at least by January, at least before 2 years is over, I can finish the commission. Otherwise, let it rest happen in court. Because we are bearing the
we are agreeable to that.
because we are bearing the expenses to it. Only one side is and one side takes two.
My lord, one witness for 4 suits. 2000 pages of volumes of document. In each of them.
Dhruva Ghosh, Lanet senior advocate, appears for the plaintiff. MS Suparna Mukherjee, Lanet senior counsel, advocate, appears for the defendant. One defendant?
Yes.
Defendant. Poster. Today the matter has appeared in the list under the heading to be mentioned at the instance of the defendant. For the reason that the time for holding commission, which is in progress, shall expire on November 28, 2025. Paragraph. Mr. Dhruva Ghosh, Lanet senior advocate, has opposed the prayer on the ground that
Not opposed. I wanted peremptory.
on the ground that the same may be fixed peremptory as the witness action must complete within a time frame before the commissioner.
And it was appointed in February 2024.
The process is being carried out for about last 2 years. Paragraph. After considering the submissions made on behalf of the parties and on perusal of record, and for the ends of justice, the time to hold commission stands extended till
My lord, may I make one humble submission, my lord? Month of December, there are holidays.
31st.
Holidays, no holiday before commission, huh?
Records are to be taken from the court.
31st January,
held-
1 year. That's
And again in
years that
January
it
also, my lord, lordship will keep it in the monthly list of February. Otherwise, my lord, let
No,
it be.
I'm just extending the time, madam. I'm not keeping it.
January 31st. Enough time. They're 5 or 600 here. My learned friend on 6
I'm
questions,
agreeable.
600. And they're agree. It's only a question of the
And you,
advocates getting the time.
agree for that? January 31.
I don't. Ideally, it
All
would
right,
be better if
what is your prayer? Till
The February.
February, end of February.
end
ma'am.
of February. So let me fix in between. Ashun.
But it'll be more than 2 years then. I wanted to 1 day before.
One
February 10.
witness giving evidence
February
in all
10.
4 matters.
February 10, 2026. That's it.
And the commissioners will try to ensure that the matter is done.
It is expected that during this period, the entire examination process shall be over.
My lord, no, that is not so. It is their first witness. In one suit which is not appearing today, all 4 orders were passed simultaneously, my lord. The first
This is for
witness
this
action of the
witness.
first witness
No,
was
for
over.
for the witness,
For this
for the
particular
particular witness,
Yes, ma'am.
Yes.
for the particular witness who is on the dock.
Yes.
Deeply obliged. Your Lordship.
এটা কটা কি হলো 3টে ম্যাটারে 3টে ফি 3টে ম্যাটারে
তো সেটার ফি তোমরা
yes serial number which to which 2 3 4
Item number 5, my lord, I am for the plaintiff, my lord. This was for non-prosecution, my lord. This is the communication from the client.
এটা 2 থেকে 4 একটাই অর্ডার হলো 2 3 4 সব একটাতেই একটা অর্ডার 2 3 4 Who is for the defendant?
I'm for the defendant, Lordship. I'm led by Mr. Bhattacharya. He's online.
But I am online. For the
Mr. Appearing for the plaintiff. Mr.
Banerjee, Sujit Banerjee.
Sujit Banerjee, learned advocate, places a copy of the written instruction received by his from his client. Comma, the same is taken on record. Full stop. The instruction shows that the plaintiff wishes to withdraw the suit. Full stop. Mr.
I'm Mr. Stephen Biswas.
Huh?
Stephen Biswas.
Stephen, spell out
Steven.
Stephen Biswas, learned advocate, led by Mr.
Debru Bhattacharya.
Debru Bhattacharya, learned advocate, bracket VC. Appears for the defendant. Paragraph. In view of the above, the suit being CSCOM 61 of 2025 stands dismissed as withdrawn.
Deeply obliged, my lord.
Comma, full stop. There, paragraph, there shall be no order as to costs.
New motion. Item number 3.
My application.
No, I'm appearing on behalf of
For
Whose application?
my application. Suit for recovery of possession termination of lease under section 106. At this stage,
Now permitted.
at this stage,
After
I-
division
now after
bench.
the division bench. At this stage, I am only asking your lordship to consider prayer A. Defendants are running a convention center after taking the property on lease from me. Only
Wait,
thing that I am
wait,
asking
wait,
is
wait.
they should not sublet or create third party interest pending the suit. I can't ask for anything else ad interim.
Yes, what do you say?
No, we have no difficulty in that.
At
You have
this
no
stage, only
difficulty.
prayer A.
No, my lord, I would be seeking, my lord, they have sought for recovery. My lord, the main,
Recovery is after the trial.
my lord, we have not created any third party
All
interest.
right, let me record your submission.
Kindly record, we don't have, kindly record that we have not created any third party.
Wait, you listen. What do I record? What will I record? Mr.
Affidavit of
Shantan
service.
Bose,
Affidavit of service. will be taken.
জানেন, আচ্ছা, মাথার উপর affidavit of service filed in court today is taken on record. Mr. Shantan Bose, learned counsel, appears for the petitioner. What's your name, sir? Mr.
Sani Nondi.
Sani Nondi, learned counsel, appears for the how many
My lord, all the defendants.
defendants?
Defendants are the partnership firm and the two partners.
আচ্ছা, ওইটা হচ্ছে plaintiffs.
Yeah.
Plaintiffs, plural. Defendants.
Defendant.
Defendants. Paragraph. The instant suit paragraph has been filed by the plaintiffs praying for recovery of cash possession along with other consequential reliefs. Paragraph. At this stage, comma, through the instant application, the petitioners oblique plaintiffs press for PRESS an order of injunction in terms of prayer A. Paragraph. In response, comma, learned counsel, Mr. Sani Nondi submits that the defendant has not created any right or interest over and in respect of the demised premises, which is the subject matter of the suit. Full stop. Paragraph. And you have received this, sir. You're not going to do that.
My lord,
You're not going to create any third party interest. You have
No.
not yet created, I have recorded.
not going to create.
Huh?
Not going to create.
Let it be in the form of undertaking by his client.
No, my lord,
First-
kindly doesn't record my undertaking.
On
But
instruction, the defendant further submits they have no intention to create any third party right or interest over the demised premises. Paragraph. In view of the above, the defendants shall not create any third party right, title, or interest over and in respect of the demised premises, comma, being the subject matter of the suit, comma, without leave of this court. Paragraph. The defendant shall file affidavit in opposition. Tell me when.
4 weeks, my lord.
আজকে কত? 24. On or before January 7, 2020.
May it be on 10th, my lord. May it be.
January 10, 10th to Saturday.
The-
January 13, 2026. Paragraph. Affidavit
Reply
in reply,
27
if
January.
any,
27th January.
if any, shall be filed by January 27, 2026. Paragraph, the matter shall appear under the heading adjourn motion in the monthly list of February 2026.
Obliged.
Yes,
Number 7. Abhishek Roy and others.
Lord, item 7, my lord, I appear for the petitioner. Last week, Mr. Rudraman Bhattacharya had attempted to move the matter ex parte. My lord had said to serve the parties and come back. Lord, I've served all the parties except, my lord, respondent number 1. They could not be served at their current address. They, my lord, have given us an alternate address, my lord, at India Exchange Place. May I, my lord, serve them and come back on Wednesday, my lord?
Lordship, I appear for the respondent number 1. They can directly serve on me. Yesterday, they have effected a service over email.
I've tried to serve them by email.
You are for the defendant number
Defendant
one.
number 1.
Give
The papers, my lord.
And
May I come?
here and now.
Lordship, the submission is that the defendant has changed the address. It is not so.
All right,
I
all
will-
right. You take it then.
We have a copy. My lord, I do not have a copy set right now. May I, my lord, serve them and come back on Wednesday?
You had so urgent, so much of urgency.
Right.
Ashu.
Only one there, my lord. Instead of Wednesday, make it Thursday.
Thursday, yes, Lordship.
No, it shows that there is no urgency. They're not even carrying their copies.
Lord,
It's so urgent.
they want a soft copy, my lord. I can give it today. That's the only.
Mr. Counsel, if you have so
I
so much of urgency, and this is the way, you should deal with an urgent matter, sir.
I apologize, my lord.
Ashu. The last order dated November 19, 2025 speaks for itself. Since serial number which to which?
My lord,
Only 7.
Only 7.
only 7.
Poster. What's your name?
My lord, Shattoki Mukherjee.
Mr. Shattoki Mukherjee, learned advocate appearing for the plaintiff oblique petitioner submits. Petitioners, plaintiffs. ঠিক আছে? Oblique petitioners submits that despite effort, comma, the respondent number 1 could not be served. Hence, an adjournment has been prayed for. Paragraph. MS
Deblina Lahiri.
Deblina Lahiri, learned advocate, appearing for the respondent number 1, submits that she is instructed to appear in the matter for her client and she can accept the service if the copies are served, a copy is served upon her. Accordingly, the petitioner, paragraph, petitioner shall serve a copy of the petition upon MS Deblina Lahiri, learned advocate, appearing for respondent number 1 and file an affidavit of service on the next day. Paragraph, Mr. Rajorshi Dotto, learned counsel, appears for respondent number 3. Who else? What about the others?
2, my lord, we have served. 2 we have served. There are
Punjab
3
National
respondents.
Bank.
Who is appearing for 2?
2, my lord, my affidavit.
আচ্ছা মাথার উপর লিখেছো the affidavit of service filed in court today is taken on record. লেখো
Service হয়েছে।
লিখেছো? আচ্ছা নিচে এবার লেখো
Service টা কোথায় রাখা হবে?
none appears for respondent number 2 stroke PNB, comma, despite notice. The paragraph, the petitioner shall serve one more notice along with a copy of today's order upon the respondent number 2 and shall incorporate the same in the affidavit of service as directed above. Paragraph, the matter shall appear under the heading new motion on December 8, 2025. 2025.
DPR.
Well, I am for the plaintiff petitioner.
I am for the defendant having a counterclaim in this matter.
Yes, my lord.
The written statement amended by the defendant, my lord, and it was served upon me.
What is this application?
This application for my lord, condonation of delay of 6 days
For
in filing my written statement against their counterclaim, my lord.
additional written statement.
Yes, my lord. So the leave was granted, and I have filed in the department only for the acceptance, my lord, because it is in the 6 days delay, but it is within the outer limit.
How come it comes within 6 days?
My lord, I have,
Plus 6.
my lord, 30 days plus 6. Court allowed.
Plus 6.
My lord.
Show me the order.
My lord, order is at page 6, my lord, page 6. Kindly come to my lord, page 22, my lord. Page 22, it is there.
Yes, I'm on page 22. Show me.
Kindly see, in view of the above, paragraph 27, the department is directed to carry out the proposed amendments within a period of 2 weeks from date. After amendment is carried out by the department, the defendant is directed to re-verify and reaffirm the written statement and to pay the requisite court fee within 2 weeks thereafter. The defendant is also directed to serve a copy of amended written statement along with counterclaim to the plaintiff. The plaintiff is at liberty to file written statement within 30 days from the date of receipt of amended written statement with counterclaim. My lord, I have received on 19th of August 25, my lord, and thereafter, my lord, it was a delay of 6 days, and I have obtained leave from the court, my lord, and filed in the department on 25th September 2025, my lord. So there was a delay of 6 days, my lord.
All right. Ashok.
Then may I make one humble submission? Look, the reason is afforded in paragraph 5, but there was no new document along with our counterclaim or amended written statement.
So basic elementary principle of natural justice.
I leave it to you.
I wonder one thing.
Master summons taken out on 14th November 2025. Your Lordship will perhaps requires these dates.
He admits that he is delayed by 6 days, 8 days.
Even I say that. Yes.
And my lord, they have filed their original written statement after 73 days.
He is accepting your prayer. Why you are Ashok? To this master summons, the plaintiff in the suit, inter alia, comma, आगे पढ़े हैं, prays for extension of time to file its additional written statements in response to the counterclaim introduced by the defendant in its written statement by way of amendment. Paragraph, by judgment dated June 13, 2025, the coordinate bench had allowed the defendant to incorporate its counterclaim by way of amendment in its written statement. And the plaintiff was directed to file its additional written statement within 30 days from the date of receipt of the amended written statement. with counterclaim. Paragraph. The plaintiff admits that there is a delay for about 6 to 7 days. And accordingly, the plaintiff prays for extension of time to file its additional written statement. The additional written statement has been affirmed.
Yes, it has been
On-
filed, my lord. It has
Oh.
been filed in the department.
Affirmed on 24th of September.
Has
2020.
already been
filed.
submitted before the department. How it could be?
My lord, in the department, my lord, when it is within outer limit, my lord, then with the leave of the honorable court, it can be department takes the written statement, and thereafter for acceptance we have to file this application. Kindly see my prayer B, my lord, for acceptance of this written statement. It has been filed. It is on
It is
record.
under which provision?
My lord, 7-1. It will.
No, I am on a very short question.
My lord.
My view is you have to come up with an application, you get the extension, file it. How the cart will be put before the horse?
Before Justice Rao, my lord, takes this practice that if it is within the outer limit, my lord, the court
Then where
directs
is the utility of filing an application?
for acceptance of this, my lord. Only for the formal acceptance of this.
কি বললাম? Show me the order for submission of written statement before the department.
That is not annexed.
When has it been passed?
Well, the averment is that 25th of September is the date when the plaintiff had submitted the written statement with the department.
Yes, my lord.
You will
Leave was obtained, my lord. It is marked on the.
Extension of time.
We have mentioned the matter. Court granted us leave.
Before the department on September 25, 2025, pursuant to the leave granted by the coordinate bench. Be that as it may, for the ends of justice, the delay stands condoned. Since this court has been satisfied with the reasons shown in the supporting affidavit. Paragraph. The additional written statement filed by the plaintiff shall be accepted formally and shall be treated as part of the suit record.
I'm grateful.
Paragraph. According paragraph with the above observations and directions, bold GA Com P of 2025 stands allowed, comma without any order as to costs. GA Com 3 touch a bold number. Huh? Sure.
Deep love.
Item number 9.
Item number 9 is my application for revocation of grant of clause 12 and for rejection of the plaint, which I'm being led by Mr. Jishli Chaudhary. He's on legs before court.
You proceed.
Your Lordship,
Could I only pray for a direction to file an affidavit to
Lordship, I would
No,
be
let
praying.
me see what is there.
Lordship, there are threefold grounds. A, that there is no territorial jurisdiction of this court. B, that your Lordship, the suit has been instituted by an unregistered partnership for enforcement of a contractual right. Therefore, the suit is barred. And this is this plaint becomes void and this defect is incurable. And C, on the ground of limitation, that the suit is barred by limitation. If your Lordship kindly
Alright.
comes
Let them file affidavit.
Lordship, may kindly hear me because I was be praying for stay of the suit, your Lordship.
Why?
Your Lordship, because if the suit
I will
itself...
direct that the suit shall not be transferred to undefended list.
Very well, Lordship, then.
That's the usual order.
Very well, Lordship, because my written statement, time to file written
This
statement,
is an application filed by defendant number or one defendant.
sole defendant, your Lordship.
This is an application filed by the defendant praying for rejection of plaint
And revocation of
And
leave.
revocation.
revocation of, and 12A leave granted.
Yes, 12 agree.
Huh?
No,
Lordship, this was
we did
after mediation.
We did after mediation.
Oh, it's mediation done then.
Mediation
Yes.
done,
Mediation
failure
failed
report.
then. Non-starter report is there.
Yes.
All right. কি বললাম? Paying for rejection of plaint and
Revocation prior.
revocation of leave under clause 12 of the latest patent. Paragraph. The suit has been instituted since the pre-litigation mediation has failed. Paragraph. Considering the averments made in the petition, in this application, and considering the plea taken by the defendant seeking rejection of plaint, comma, the respondents are required to file their affidavit. The respondent plaintiff,
Respondents, plaintiffs.
respondents oblique plaintiffs are required to file their affidavits. Paragraph. Mr.
Varun Kothari.
Varun Kothari, learned advocate, led by Mr. Jishnu Chaudhary, learned senior advocate, appears for the defendant. Paragraph. Mr. Chayan Gupta, learned counsel, appears for the plaintiff. Plaintiffs.
Plaintiffs.
Plaintiffs, plural, defendant actor. Paragraph. Accordingly, comma, the plaintiffs oblique respondents shall file affidavit in opposition on or before January 7, 2026. Affidavit in reply, if any thereto, shall be filed by January 28, 2026. 26 kintu সব কটা. Paragraph. The matter shall appear under the heading Chamber Application for final disposal in the monthly list of February 2026. Paragraph. In the meantime, comma, the suit shall not be placed in the undefended DD, undefended list.
Grateful.
And your lordship, my time to file written statement will stand stayed.
Well, that is.
Can that be done in a
Lordship,
rejection of plaint application?
Lordship, that is why I was
If you
I was
succeed,
praying for
then
stay
it
of
will
these
be
two.
taken into account. If you succeed, then automatically the plaint goes. If you don't succeed, your time will fly.
very well, Lordship. Grateful.
There is no bar that you cannot file your written statement.
No, your lordship, there's no bar. I was praying for stay of the suit. Very well, Lordship.
Yes, I did. I asked for that not to be transferred before the undefended.
Very well.
So
Great.
commercial litigation, sir.
Grateful.
The reason for application is for that, to get that time extended for whatever reason.
Great.
My lord, I'm for the decree holder, my lord. In this matter, my lord, we have settled this amount to 65,000 and the Honorable Court directed 65 lakhs, my lord. Honorable Court directed them to pay in 12 installments, my lord.
We are
So,
already paying on
they have
time.
paid
Lord.
Aja, one second. Just call them. Udhar dako.
To last order.
There shall not be any confusion. কোথায় গেল? Where is the other side? I will clarify on the contrary, so that there shall not be any confusion.
Yes, sir. Lordship.
Ashun. Where is Mr. Chayan Gupta?
He's on the next question.
দেখো ঠিক আছে দেখো pendency of this application shall not preclude the defendant to file its written statement in accordance with law, comma, without prejudice to its rights and contentions in this application.
Grateful, Lordship. Very good.
Pendency of this application shall not preclude the defendant to file their written statement in accordance with law without prejudice to their rights and contentions.
Grateful.
এটা কার? পরেরটা? আচ্ছা।
So there was an order, my lord, to pay them 65 lakhs rupees in 12 installments. They have paid 2 installments, my lord.
As per the
So,
directions, Lordship.
for the
We are paying
direction-
on time.
What is the application for?
Application, my lord,
For
it is the
execution.
application.
So I'm adjourning, let them pay.
Yes.
Let them pay, my lord.
It may appear, Lordship, in the monthly list of January again after 2 months if your Lordship pleases, or else.
They will mention.
Yes.
Ashu.
That's
Let it appear in January, my lord, because
This is an application for execution of a decree dated
decree dated.
decree dated, my lord, 17th of January 2025, my lord.
January 17, 2025. Paragraph. Paragraph, no shangi. Full stop. It is a money decree. Full stop. Paragraph. Both. Acha. Mr.
Sunil Singhania.
Sunil Singhania, learned counsel, appearing for the plaintiff / decree holder, and MS
Gargi Roy and
Gargi Roy, learned advocate,
Anita Kundu.
appears for
The defendant.
how many?
Lordship,
One
only
defendant. One
has
defendant.
been
The
dated.
defendant,
Senko Jewelers.
Senko Jewelers.
the defendant judgment debtor
Judgment letter.
submits that pursuant to the arrangement arrived at by and between the parties, the defendant the judgment debtor has agreed to pay off the entire dues by
12 installments.
12 equal installments, and out of the same, two installments have already been paid in time.
Yes, sir.
Full stop. Paragraph. In view of the above, the execution application stands adjourned sine die. Full stop. Paragraph. The parties shall be at liberty to mention the execution application either in the event of default or after the entire decretal dues will stand satisfied. Will be satisfied. Will stand na kore, after the entire decretal due will be satisfied.
Deeply urgent.
কি করেছিলেন যেন? Decree for 1 crore 32 lakhs.
Lordship. Right, 1 crore 27, my lord.
No, kindly come to page 18, paragraph 30. Or paragraph 22. No, with interest.
Yes, with interest.
Ashun. Injunction is prevailing
It's
on
prevailing
that
till
immovable
disposal.
property. On that immovable
That
property.
removable and the 2 bank accounts. 1 bank account, I'm sorry, my lord. In the meantime, if I can find another address, I shall be praying for
Where is the injunction on property?
the paragraph 5, my lord.
Bank account I find. Oh, property.
Also restrained, lordship.
Ashun. This is an application for execution of a decree. Of a money decree. For a money decree for a total sum of rupees 1,32,87,960.85. Poro. Post. The previous order dated paragraph, September 8, 2025 shows an order of injunction has already been passed by the coordinate bench on the bank account and the immovable property mentioned in the application, mentioned in the supporting affidavit. Where is your affidavit of service?
I have filed, my lord. It's come.
একদম মাথার উপর হচ্ছে affidavit of service filed in court today is taken on record. Tapa. The affidavit of service filed in court today shows that service has not been effected as the notice was returned with the postal remark
Left.
Paragraph. In view of the above, the decree holder plaintiff shall cause the substituted service once at the widely published local newspaper at
Lordship, this is
where the plot is there.
Secunderabad. No, Shendrabad. I don't know, my lord. Should be Secunderabad. Kendra 5, Aurangabad.
At outside of Aurangabad Municipal Corporation, yeah.
Oh, outside.
কি বললাম?
The district Aurangabad. District is Aurangabad, but outside the
Substituted service along with the gist of the injunction order in a widely published newspaper where at the area where the immovable property mentioned in paragraph 27 to the supporting affidavit is situated. Where at the bank account? And where is his?
Gurgaon. They are also their registered office in Gurgaon.
Once at a local newspaper with a wide circulation.
And it is in New Delhi. Vasant Kunj, New Delhi.
At New Delhi. And once in Times of India, All India edition. Once in a widely published newspaper at the area. Once in At হবে না, in. Times of India, comma, All India edition. Full stop. The returnable day of the execution application shall also be mentioned in the said publications. Full stop. The petitioner shall file an affidavit of service incorporating those newspaper publications on the next day. এগুলো প্যারাগ্রাফ কিন্তু সব আলাদা আলাদা। Next. The matter shall appear under the heading New Chamber Application on
You need to have 4 weeks, my lord. Or 6 weeks.
19th February, February 19, 2026. So, your injunction is there. What else?
Great.
Written number 12, Star Byproduct, the private limited.
My execution application, my lord, for the first time it is appearing. Now the decree of 21st of July, they say of this court.
On notice?
No, I have not served notice on them. I have not served notice because this is the first time. Now, my lord, it's the decree which was passed, it on a judgment upon admission application.
Money claim.
Money claim. 84 lakhs and odd money claim. Now, I must also indicate that while moving the judgment upon admission, we attempted to serve them. The writ of summons was attempted to be served on them. The address in Crooked Lane, it was found that door locked. When the postal article came back, unclaimed. It was treated to be a deemed service because the company was having an office over there, and the ROC portal, everything, the same office is there. So, and the court proceeded. We got this decree. In the meantime, we moved an injunction application also because they were siphoning away their funds. A receiver was appointed to go to the Crooked Lane office, make an inventory. There's a huge factory in Benares Road, Howrah, 150 katas of land. The receiver of this court went there, made an inventory. Inventory was done. Thereafter, the Order 12 Rule 6 application was heard and decree was passed and the suit was disposed of. And even the injunction is no more because the final decree has been passed. Now, the receiver's report I have annexed, which records that the property is there. He has sold away a portion, around 7-8 katas of land. It is nothing, but the rest is there. The receiver has been there.
Benares.
Not Benares, Benares Road.
Benares nearer to your residence, Benares. Then
it's Benares Road. So now today, my lord, this office address, which is at Crooked Lane, if I serve them, it is still they are not using it because there are other offices in the same.
Serve at the Benares address also.
Yes, it can be served at the Benares Road. It can be served. And another. In paragraph 12, I have given the address of the director's residence. So this is the name of the directors we have given, my lord, which is director's নামগুলো কোথায় দেখলাম একটু আগে?
Show me the Benares Road property and the appointment of receiver.
My lord.
Where is the schedule?
The receiver's report is at page 18, 18.
Wait.
That we will have to see the handwritten page number. Yes, the handwritten page number. Page 18 is the receiver's report. The Benares Road 18. 18.
Annexure G.
B for Bombay.
18 is an email.
Execution is the report. But just after the decree.
Star Pipe, Ashirwad Foundries.
Yes, the receiver's report.
কোথায়? এই তো 18.
কি লাগিয়েছো? দেখো। দেখো 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 এটা তো ডিক্রিটা হয়ে গেল উল্টাও হ্যাঁ আর একটু উল্টাও উল্টাও হ্যাঁ এই যে ও না 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 ঠিক আছে ঠিক আছে ঠিক আছে দে দে। ওই যে ডিক্রিজ the drawn up decree is also there and the internet copy printout is also there. So there's a bit of confusion. But this is page 18. This is the receiver's report which starts, my lord.
You show me that he has visited that
Yes,
immovable
my lord, will
property.
give me 1 minute, which is first, lordship will come to page 22. He had a Axis Bank account.
Forget it.
Yes,
Show me-
the
show me the
account
property.
is zero. The
Account
crooked lane is page 23. The crooked lane issue is at page 23. And page 24 is the Benares Road issue. Benares Road, it records, Manad, in the page 24, last 7-8 lines. It transpires from inquiry said factory is stretched over 150 katas of land.
She has visited.
Yes, she has visited.
Show me, take me to that.
Malad, see. In compliance with the said order, receivers along with the advocate visited the office of the premises at 46, 47, 48 E Road and P34/2 Benares Road, Lilua on February 28, 2025, said premises and arrived at 2:50 p.m. at the entrance of the said factory was secured by way of
Injunction on the property is also there.
was there, now is not there anymore.
In execution, there is no.
No. It was not there.
This is an application. This is an execution application arising out of a money decree. The decree is dated
21st of July 2025.
July 21, 2025 for a sum of rupees
84,69,294.
84,69,294.
Plus interest.
Along with
Along
interest.
Sorry, man, it's along with interest. It's not a plus.
Paragraph. It shows that nowadays you are more interested in plus.
No, I shouldn't have.
You will
I shouldn't have.
You will
Along with interest. What this colloquial? No, I know that. This colloquial words plus.
Full stop. Nothing has been paid.
No, nothing is paid. Nothing is paid.
Full stop. Nothing has been paid.
Nothing. Commercial suit.
Paragraph. The record shows that previously at the interim stage of the suit, prior to decree, an injunction application was moved in which an order of injunction was passed on the bank accounts
Injunction order dekhi to.
and receiver was appointed over and above the two premises which were identified to be of the defendant decree judgment debtor stroke judgment debtor. Full stop. One such immovable property is premises number 1 Crooked Lane, Kolkata 7,69,000 bracketed for short Kolkata property. Paragraph. The other one is premises numbers 46, 47, 48. Capital E Road and P34/2 Benares Road, Lilua.
It is not
Howrah.
48E. It is not 48E. The name of the road is E.
That's right.
That is that. The name of the
So
road is
3 and 4 properties.
No, it's one property having multiple address. Because it is
multiple premises.
Yes, multiple.
কি বললাম? একটু পড়ুন দিদি।
Sorry, madam.
একটু আগের থেকে।
বললাম 48 করে দেবে।
Crooked Lane. CROOKED. ঠিক আছে? হ্যাঁ।
রিসিভার পরের অর্ডারে রিসিভার
ই কথাটা বোল্ড কোট আনকোট উইদিন ইনভার্টেড ই রোড কমা বেনারস রোড কমা লিলুয়া কমা হাওড়া ফর শর্ট হাওড়া প্রপার্টি। একটু পড়ুন প্রথম থেকে ওই রিসিভার ইনজাংশন যেটা বললাম।
ব্যাংক বললো ব্যাংক টাকা নেই কি করবে? 200 টাকা পড়ে আছে।
The record shows that the records and the submissions made on behalf of the decree holder show that
নিজেদের রেকর্ড করছে না।
which was identified to be the properties of the defendant stroke judgment debtor where have you in the execution proceeding described those property with particulars?
Well, in the column
Have
10,
the statement.
column 10, B Roman 3, Roman 4. Next page.
Column 10.
B is a fit and proper person appointed receiver. B, Roman 3.
Both properties.
Roman 3 and Roman 4.
কি বললাম?
খুশবু কার অর্ডারটা কোথায় গেল? এখানে খুশবু অ্যাপয়েন্ট হলো।
আচ্ছা, one second.
নিকালো।
Affidavit of service you have filed today?
No, I'm not served.
It's moving in ex parte.
Yes, because two year. না এখানে কোথায় সেটা?
The said interim order of injunction and the appointment of receiver which were passed prior to the suit being decreed, comma, are no more in existence. As the suit has already been decreed and the decree has been put into execution. First paragraph. Where is the bank account particular?
Well, the bank account particular is কোথায় গেল? Operating the bank account.
Not there.
No, it was there.
Not there.
The Axis Bank is 200 rupees. The receiver's report records. Yes, receiver report records it. I'll show you. That is there.
No, but in any way, not required.
Yeah, not
Correct.
required.
Come on.
That is in page 22. At 200 rupees.
Come on. কি বললাম?
Bank has informed. That is not required.
Comma দিয়ে, as the suit has already been decreed. Post. Today the petitioner moves this execution application ex parte. Paragraph. Considering the fact paragraph, that the decree has been passed, comma, the claim of the plaintiff has been crystallized, and since this no appeal has been preferred from the decree, comma, liability is crystallized against the defendant. The decree must be protected. Prima facie, comma, prima facie. Paragraph. In view of the above, the same learned receiver,
Khushbu Chaudhary.
namely
Khushbu Chaudhary, my lord. Lordship will find the name in the receiver's report, my lord. At page 25, the spelling is
same learned receiver, MS Khushbu, আপনি ভালো ঠিক করে লিখুন, KHUSHBOO CHOUDHARY, Chaudhary, Khushbu Chaudhary, comma advocate, comma a learned member of the bar, is appointed receiver over and in respect of the immovable properties described in clause Roman 3 III and Roman 4. 2. Prayer B to the tabular statement. Poster. The learned receiver shall visit the premises of the properties and make a detailed inventory with regard to its present state, comma, status and situation, and then file a report before this court on the next day. Paragraph.
They should remain in symbolic position.
Paragraph. There shall be an order of injunction restraining the defendant judgment debtor
Company, yes, one.
Singular,
yes, one.
and or its men, comma, agents, comma, servants, comma, assigns from dealing with and or disposing of and or creating any third party right, title or interest over and above the immovable properties described in Roman 3 and Roman 4 to prayer B to the column 10 of the tabular statement in any manner whatsoever until the execution proceeding is disposed of. Full stop.
Symbolic symbolic position should remain, not physical. No.
But for the time being, let an inventory be made and this injunction remains. Full stop. The learned receiver, paragraph, shall be paid
inventory is in a suit. This inventory is in execution.
remuneration of rupees 30,000 for the time being, and the same shall be paid by the decree holder at the first instance. Full stop. The decree holder and its advocate on record shall arrange for the necessary conveyance of the learned receiver and to return her to her place of destination. That's all.
On the service, I have to serve then. So,
Paragraph.
And may I have a liberty to
The petitioner, the judgment debtor, applicant, the decree holder, applicant shall serve a copy of the execution application along with a copy of today's order upon the defendant judgment debtor at its recorded registered address
Howrah.
and also at both the properties and also at the properties mentioned in prayer B to the column statement, prayer B to the column 10 of the tabular statement.
And I have another address given where the directors reside. That must be in The Condoville
The
in
petitioner shall
bypass.
also serve a copy of execution application along with a copy of today's order upon the directors of the judgment debtor company showing their residential addresses,
Perfect.
showing their residential addresses
Jugaad karo. It can't be 100.
as per the record of the register of companies.
Register of companies.
West Bengal.
We'll get it. In the ROC, we'll get that.
Paragraph.
January.
The matter shall appear under the heading কিসে আছে?
New chamber.
New chamber application on January 29, 2026. অসুবিধা হয়েছে ম্যাডাম? কোনো বুঝতে কোনো কিছু বা কোনো জায়গা মিস করে গেছেন কিছু নয় তো?
My lord, 13 and 14, my lord, in item 14, I am the plaintiff, my lord.
I am
In
the
item
defendant number
14,
1, your lordship.
They have filed a section 8 application, my lord.
You are for?
I am for the plaintiff, my lord.
My
They
lord,
have filed an application under section 8, my lord, which is listed as GA2 in item number 14.
That has to be heard.
my lord, there are two applications. If I may take very short time of your lordship, there are two interlocutory applications on board. Item number 13 is their injunction application, which is GA1. Our application is GA2, which is for in the nature of referring the matter to
Section 8,
arbitration under
section 8.
section 5 and 8. So this particular matter, the demurrer under section 5 and 8 was heard extensively by Justice Krishna Rao. Mr. Ratnanko Banerjee, my learned senior, he was arguing the matter and rejoinder was left. Now, since the matter is before your lordship, it has to be heard out afresh. And there are also a couple of Delhi lawyers who are involved in this matter. So I was urging if the matter could be fixed on a particular date so that they could travel accordingly. I leave it entirely up to your lordship.
Yes, what do you say?
Ever.
Ashu.
My lord, and if a date could be given post 16th of December, I would be extremely grateful. If it would be kept on the 17th or 18th, subject to your lordship's convenience.
কি বললো লেখো? দুটোই একসঙ্গে হবে সিরিয়াল নাম্বার, একটাই অর্ডার। Out of the aforesaid two matters, comma, IAGA com 290, no sorry, IAGA com 610 of 2024 is an application filed by the defendants.
My lord, it's only the demurrer is only by the defendant number 1 for whom I'm
Filed by
appearing.
the defendant number 1 inter alia under section 5 and 8. কোথায়? এটা কত নম্বর? ও এটা 13 and 14, আমি পরেরটা দেখেছি। So it should be IAGA 2.
Yes, the demurrer is IAGA2, which is
Alright,
item
right.
14 your lordship.
IAGA 2 bold করে দেবে, হ্যাঁ, of 2025. এত না মানে নম্বরের কমপ্লিকেশন। IAGA 2 of 2021. 2021. IAGA 2 of 2021 bold. কিভাবে লিখেছি? Two applications. Matters না করে two applications. Of the Arbitration and Conciliation Act 1996. Full stop. This has to be heard first.
Absolutely. your lordship.
As the other application has been filed by the petitioner, plaintiff, oblique petitioner for injunction. Paragraph. On the prayer of Mr.
Shourodip Banerjee, Your Lordship.
Shourodip Banerjee, learned counsel appearing for defendant number 1.
Absolutely, Your Lordship.
Today's hearing stands adjourned. And the matter shall appear under the heading adjourn motion on December 17,
I'm grateful.
2025. Mr. Shatodru Chakraborty, learned counsel, appears for the plaintiff. Learned senior advocate. Shatodru Chakraborty, learned senior advocate, appears for the plaintiff.
Grateful to Your Lordship.
May it please, Your Lordship, but I'm appearing for the respondent in the petition. My lord, it is my plaint.
My lord, I am
It was
for defendant number 1, my lord. I'm led by Mr. Anirban Rai, my lord. If it should be.
But this is that matter where I had opposed last year. It said because my learned juniors are appearing, I will not oppose if they want time. But today, my lord, may I only indicate that I'll indicate the premise of the matter.
No, either it has to be proceeded or
We are ready. We'll proceed, my lord. We are ready to.
For the respondent number 2, Your Lordship, the insurance.
Defendant number 2 is it's already an undefended suit against them, my lord. And I'll indicate what is the reason, because today, my lord, by an order of
wait.
my lord.
Yes,
My lord, I am led by Mr. Anirban Rai.
you proceed, madam.
My lord, if it could be fixed, my lord, on Thursday, my lord.
No.
because- My lord, only.
That small application, my lord,
Yes,
to
my lord, this is my
transfer.
application, my lord, for transfer of the suit, my lord, from commercial division to my lord, non-commercial division.
Proceed, move it.
Yes, my lord.
Move it.
But this is my lord.
This is GA8.
G8.
Yes, ma'am.
G8 is the
proceed.
petition. Basically, recall of an order passed by this honorable court, my lord, on 1st March, where, my lord, they were present. I'll show that. In their presence, it was transferred, my lord, from the non-commercial to the commercial division of the court.
Now they are paying for,
Now they are paying for
retransfer.
recall of that order.
Retransfer from commercial to non.
Retransfer. Without there being any change
Show
in
me the
facts
plaint.
of the matter, my lord. I'll indicate.
My lord, before my
You
lord,
take your seat.
my lord, before starting, my lord, may I indicate in brief the facts of the matter, my lord, the plaint.
Madam, not required. You just take me through the plaint. Because it is basically the plaint has to be read, and if I find it is non-commercial, matter ends.
This is, my lord, a simpliciter money suit.
Show me
for
from the
damages, my lord. Yes,
Show me from the plaint.
kindly, my lord.
ঠিক আছে, হ্যাঁ? এতে লেখা রয়েছে। Show me from the plaint and demonstrate that it has no, it doesn't have the character to become a commercial suit. Matter ends.
My lord, my application, my lord, page 17, my lord.
Plaint starts.
Yes, my lord. Plaint
Come to
starts.
page 18 and proceed.
Yes, my lord. My lord, kindly see, my lord, how I am described in this. My lord, the
You take you take the plaint from the beginning. I don't mind. Yes. Read, sir.
My lord, page 18, my lord, paragraph 1. My lord, the plaintiff carries on business as a sole proprietor under the name and style of Dini Travels and Tours as a travel agent, and has been a member of International Air Transport Association. I am, my lord, International Air Transport Association. IATA is defendant number 1, is a body corporation of Association of Transporters. My lord, I am also an association of, my lord, airlines. My lord, one of the member airlines is, my lord, Air India. My lord, there was, my lord, kindly comes to paragraph 4, my lord. Here, my lord, there was an agreement between the plaintiff and Indian Airlines Limited. There was a, my lord, sales agency agreement sales agency agreement between plaintiff and my lord Indian Airlines. I was not a party to that agreement.
What is the nature of transaction, madam?
What is my lord?
What is the nature of transaction between plaintiff and Indian Airlines?
Yes, my lord.
Indian Airlines is a party.
Indian Airlines is not a party, my lord, in the suit. My lord, if my lord kindly, my lord, see, there was an agreement entered into between the plaintiff and Indian Airlines under the scheme introduced by Indian Airlines for promoting Calcutta, Bangkok, Calcutta sector. My lord, if my lord kindly comes to the agreement, which my lord,
you read on first, then we will see the plan.
the copy of the agreement, similar agreement for the period of 15th December 2004 to 14th December 2005 between the plaintiff and Indian Airlines is annexed here to and marked with B. Shortly after commencement of 2004 and 2005 agreement, a force majeure situation occurred. On 26 December 2004, tsunami hit Thailand in a major way. The seaside resort of Phuket, Pattaya, and others were devastated. The entire coastal area of Thailand was struck by tsunami, which not only hit tourist industry in Thailand, but had severe impact on Thailand's trade and commerce industry. The effect of tsunami on air travels to Bangkok was very serious. This also applied to other Southeastern Asian countries like Malaysia, Singapore, and Indonesia. As a consequence of tsunami, the big tourist session of Thailand, Christmas and New Year 2004 was severely hit. Almost all the passengers cancelled their flight. This decline in traffic to Bangkok continued during the year 2005. In fact, normalcy has been restored since after the month of May 2005. Till that time, the tickets of sale for Calcutta, Bangkok, Calcutta suffered major losses. The plaintiff states that decline in the ticket sales for Calcutta, Bangkok, Calcutta sector was not only in case of plaintiff but also across the world across the travel industry. The plaintiff reasonably expected the travel business to pick up from May 2005 and consequently meet the target for the year 2005-2006 under the sales agreement. There has never been a default on the part of the plaintiff in reimbursing Indian Airlines the value of the travel document and tickets issued by the plaintiff in Indian Airlines. The plaintiff's track record with other airlines, domestic and international, is equally impeccable. Indian Airlines, my lord, now it's demonstrate how Indian Airlines issued notice dated 30th August 2005, a copy whereof is annexed, alleging shortfall in the target per quarter in the terms of the agreement for 2004-2005. This was replied by the plaintiff's letter dated 7 September 2005. In Indian Airlines, by a letter dated 23rd September 2005, a copy whereof is annexed here to demanded payment of rupees 99,96,758 as a differential amount between the normal price and the agreed price of the number of tickets sold by the plaintiff under the said agreement till 2nd July 2005. The claim of 99,96,758 by Indian Airlines is illegal and not in terms of the agreement between plaintiff and Indian Airlines, for which purpose the plaintiff has already filed a suit being CS number 23 of 2006 in this honorable court.
That is maintained in non-commercial.
Yes, my lord, that is there in non-commercial. That has not been transferred yet.
Not to our knowledge.
And that is also not to our knowledge. My lord, till up to here, my lord, it demonstrates what is the relationship between the plaintiff and Air India. My lord,
Indian Airlines.
Indian Airlines, sorry, my lord. So, my lord, there is no privity of contract as of me and
now let us see how he has proceeded
against
you.
Yes. Now defendant number 1 by a
Which-
letter dated 16th December 2005 demanded payment of the said disputed amount of 99,16,798.
Acha. How you are related Quay Indian Airlines?
Indian Airlines is a member of
Take the microphone. You're doing very well. Keep it up.
Indian Airlines, my lord, is a member of dependent
IATA.
number.
Absolutely. IATA.
Yes, my lord, and we can, my lord. Yes. My lord, defendant number one, my lord, Air India is a member company of defendant number one. And that is the reason, my lord, we have, being Indian Airlines being a member company, we can, my lord, issue, my lord, letters. But however, my lord, there is no agreement between plaintiff and defendant.
No, madam. The moment you issue a letter,
Yes.
right? If you say there is no privity between you and the plaintiff, then why should you issue a letter?
Because there was, my lord, a sales agency. The sales agency agreement, my lord, was between Indian Airlines and plaintiff, not
Correct.
defendant
So
number one.
defendant number one was not a party to the sales agency.
No.
So under which authority you call upon the plaintiff? It is a transaction according to you between plaintiff and Indian Airlines. How could you come in?
My lord,
How could you come in?
yes, my lord, for that, my lord, there is no document in the plaint. How they have made us a party. That is also not, my lord, very much.
Question of trial. Question
Yes.
of trial.
So in
Question
that,
of trial.
even my lord, if we come on the next day only with respect to this one.
Your senior is there, Mr. Banerjee.
Yes, my lord.
Let him.
But I'm less equipped than my learned junior. She was doing wonderfully well. The moot question here, Milord, in this, so far as Milord today's hearing is concerned, whether Milord this constitutes a commercial dispute or not. Milord, the dispute canvassed Milord in the plaint, whether this constitutes a commercial dispute or not. Kindly, Milord, have a look at the prayer portion, Milord, of the plaint. Milord, in turn, Milord, I also have a senior. Kindly, Milord, have a look at Milord clause prayer B. Milord, firstly, kindly take Milord prayer A. This is Milord the principal prayer that Milord my learned friend has asked for, claimed. 5 crore Milord is pecuniary relief that Milord he is claiming. As Milord pleaded
By way of
31 and 32 Milord, that's the prayer. Now Milord kindly come to
5 crore by way of damages.
yes, yes. Kindly Milord come to now paragraph 31.
Sales agency agreement terminated by whom?
By Milord the defendant number 1, that's Milord the pleading at page 29, paragraph 24.
So if you have terminated the agreement,
Yes, sorry.
if you're not a party to the agreement, how could you terminate it?
There lies, Milord, the beauty of the matter. Milord, in the Pune suit, which Milord we must draw to my Lord's kind attention, Milord, their case is that Milord there is no privity of contract between us, which my learned junior Milord was Milord canvassing, addressing
So
before your
if that
lordship.
be so, then you have no right to cancel the also.
Milord, that's the subject matter of dispute, Milord, there in the Pune suit, not Milord here. Kindly, Milord, have a look at Milord the relief scheme.
No. The defendant number 1 illegally and unlawfully declared the plaintiff defaulter and terminate the sales agency. So if the defendant number 1 has terminated the sales agency agreement with the plaintiff,
that termination is possibly Milord not under challenge here. Kindly, Milord, have a look at the prayer portion.
may not be. Kindly see the rest of the paragraph. Kindly come to 31.
Yes, Milord.
As a result whereof,
Correct.
the plaintiff have suffered substantial loss and damages.
So, Milord, this is basically.
So definitely it is a subject matter, because otherwise how prayer A will be correlated with
at
this.
the best, Milord, a suit for damages.
So Kwe the defendant number 1.
Correct.
Yes.
So, Milord, whether Milord, the question would be, Milord, whether such a
Yes. Accurate. Yes.
whether my lord, such a suit for damages, my lord, can be termed as a my lord, commercial suit or not. And that
Let
is
us see the definition.
yes,
I'm coming after 5 minutes.
very well, very well. Evening.
Yes.
My learned senior.
Yes.
Well, the transaction which has been thought to be made out here, my lord, the maximum interpretation I can give. And then I'll take a lordship to the plaint as to what has been stated in the plaint. It appears that IATA is a organization under which.
No, Mr. Ray, the principle is that only the plaint has to be looked into.
Absolutely.
So let us read the plaint.
First of all, the agreement is not on the plaint.
Correct. I admit that there is no.
If there is no agreement, my lord, first of all, my lord, sine qua non and the primary condition, my lord, for a commercial dispute to be a commercial dispute is that there should be an agreement.
Later on?
There should be an agreement. My lord, I'll take your lordship to that. My lord, kindly takes the commercial courts act, my lord.
ঠিক আছে পেয়েছি বসো Yes.
And let us come to 21C. Well, 21C talks about commercial dispute means a dispute arising out of one is ordinary transactions. Then export or import of
ordinary transactions of merchants,
merchants,
financiers,
yes, and traders such as those related to mercantile documents.
Relating to mercantile documents, including merchant transaction is a wide import.
No, Malad, that has to be pleaded.
All right.
Malad, they cannot just, Malad, we are not here to support them, Malad. And neither will the court do it because Malad, after HON'BLE Sarabhai, Malad, HON'BLE Sarabhai says yes, but you will have to give it a narrow interpretation so that people do not come at the drop of a hat and avail the expeditious nature of this proceeding, Malad. So, Malad,
is it a fact that previously when the suit was transferred from non-commercial to commercial, then it was in your presence, I mean your client's presence?
I'll have to check that, Malad. Mr. Banerjee was appearing, it appears. Mr. Banerjee was appearing.
You may not know, that's all.
No, I didn't know. I appear Mr. Banerjee. Absolutely. Whatever it is, this is a question of law. Now, whether I'll be hit by the any point of admission, then I'll have to make submissions on that, because I'm not prepared for that. But it would not, there wouldn't be any estoppel against the statute, Even if I've been there, if it comes to the knowledge, my knowledge at this moment that no, it cannot be a commercial dispute, but I think I can argue on that. Yes. I don't know whether he's going to take that point. I was not prepared for that.
He started his submissions.
Then I'll have to get some assistance. I'll go on this first, Malad. Then, Malad, kindly sees, Malad, 2, 3, 4, Malad. Malad, there are certain changes in the wordings, Malad, if your lordship kindly sees, till, Malad, 5. Well, see, first 2 is export or import of merchandise or services. Issues relating to Admiralty and Maritime Law. Now, this keeps it wide, Malad. Kindly sees issues. Then transactions relating to aircraft, air engineer, aircraft equipment, and helicopter, including sales, leasing, and financing of the same. Carriage of goods, construction, infrastructure, contracts. Now contracts coming, including tenders. Then, my your lordship will find agreement relating to immovable property, franchising agreement, distribution licensing agreement, management consultancy agreement, all agreements. So, my lord, basically, my lord, claims, tortious claims, my lord, may not be available in this commercial dispute.
Has the agreement been denied, defined under the Act?
No, it is not.
So it may be oral, it may be.
But if it's oral manner, oral agreements are to be pleaded in a separate manner. That has not been pleaded here. They are saying there's an agreement. The agreement is not before your lordship. There is not before your lordship.
No, they are saying there is an agreement between his client and Indian Airlines.
But he has not said that. He has not said that. But I'll read the plaint. But he's saying a lot of things. But his saying will not do the.
No, absolutely.
Obviously, Malad. So I will have to show from the plaint what is his pleading that makes this commercial. That is what I need to show. Now, Malad, to fall within commercial, Malad, he'll have to define
the transaction.
I'm grateful, Malad. So, my lord, let me for my sake, my lord, take his case first. First, he says that there is an agreement between different number 1 and different number, not different number 2, Indian Airlines. There is an agreement. Now, that agreement, if there is an agreement, my lord, that is between different number, that is between me and the different number 2, Indian Airlines. Now, with his agreement, with whom does he have the agreement?
Let's see the plaint.
Yes, let's go through the plaint. I'll just complete this and take your lordship, my lord. But then your lordship will kindly come to, my lord, 21 kindly. My lord, I'll just show 2 more.
Yes, yes, you place in your own way.
21, my lord. I mean, small Roman 21, my lord. Contracts of agency relating to any of the above. So it's not all agency agreements. Agreements which are agency agreements relating to whatever is up there. Now, my lord, up there is nothing of such agreement which he's trying to relate to. So now if he tries and shifts, saying there is a contract for agency, my lord, then in that event, my lord, I am of the view, my lord, then he won't be able to get commercial dispute.
Whatever shifting, no shifting, doesn't matter. Let us read the plaint.
No, my lord, I'll have to read the plaint. Yes.
Yes.
The document I'm trying to identify myself.
No, but Mr. Rai, those comes later. First, let us read the plaint with the plain eye.
If I don't see the agreement, my lord, even your lordship, my lord, would not be in a position to understand. If we don't know what is the agreement, my lord, how would we decipher which is commercial
That
or
is
not?
why we let us.
Yes,
read
well,
the
let us
plaint.
go, my lord.
Let us
My
read
lord,
the
kindly
plaint.
takes it, my lord, page 15 onwards.
Absolutely. You place it from your own way.
Yes,
No
yes.
problem.
But I cannot place it in my own way. I can only read it.
Absolutely.
Because we are plaint, so we cannot add.
17.
17, my lord. So,
Read.
my lord, the plaintiff and the defendants are, one is me, and defendant number 2 is the Oriental Insurance Company. Now, my lord, kindly sees the plaintiff, para 1. The plaintiff is carrying on business as a sole proprietor on the name and style of such and such, and has been a member of the International Air Transport Association. So he's saying he's my member. Then he's saying different number 2 is now kindly says 4. There was an agreement.
Let us read. Let us read.
But 3,
Then 2.
2.
IATA is a abundant body and not required. Come on. 3.
That is why I did not place it.
No, you are absolutely.
3 is the different.
No, you have read the plaint much more than me, of course.
5 minutes, my lord, just now. But I was just told.
Acha.
Now, defendant number 2.
Defendant number 2 is a
insurance company.
Forget.
Now, 4. There was an agreement entered into between the plaintiff and the Indian Airlines. So I'm not there. Under a scheme introduced by Indian Airlines for promoting the Calcutta Bangkok Calcutta sector, copy of such agreement is Annexure A. Similar agreements for the periods such and such and such and such between plaintiff and Indian Airlines. So they are talking about they have their agreement
with a non-party, who is not a party to the suit. Indian Airlines.
Not a party to the suit. Shortly after the commencement of 2004-5 agreement. So this agreement they are talking about, my lord, is referring to para 4, para 5. Shortly after the commencement of 2004-5 agreement. This agreement is referring to the agreement between Indian Airlines and plaintiff. A force majeure situation occurred. Tsunami hit, severe impacts. Then, my lord, 6. Impact was very, very serious, not very consequential. 7. Big tourist season to Thailand was hit.
These are the description of.
I'm not reading it. Now, my lord, 8, my lord, is that he was expecting that the travel business would pick up. Then 9. There has never been any default on the part of the plaintiff in reimbursing Indian Airlines. The value of the travel document ticket issued by the plaintiff on Indian Airlines. The plaintiff's track records with all other airlines, domestic and international, equally impeccable. Then 10. Indian Airlines issued a notice alleging shortfall in the target as per quarter in terms of the agreement of 2004-5. Then, my lord, payment demanded of 99 lakhs odd.
Indian Airlines.
Indian Airlines. claim of 99 Indian Airlines is illegal, not in the terms. So therefore, he files the suit.
The claim of Indian Airlines is illegal. Okay. He files a suit which is maintained before any other court.
No, this court, my lord.
CS. So
that I believe
it is a suit filed by plaintiff against Indian Airlines.
Yes, my lord. That appears to be a regular suit, but whatever it is.
Whatever it is.
I'm not on that.
Next. Different 13.
My lord. Praise your lordship will kindly
No,
see.
13. Page 23.
Well, I'm on 22, my lord. The prayers, my lord.
Watch in the plane.
Yes.
I thought the prayers from this plane.
No, that is still, my lord. We have to wait for some time more.
All right.
Decree for 10 crores, plead in paragraph 34, ordinary incurring to damages. Then declaration that clause is in the outbound group of international sector agreement for the
Mr. Pranit Bagh. Mr. Bagh, show me the copy of that plan.
Lord, I will. Is there? Yes. We don't have it handy, but my lord, for answering this issue.
No.
My lord.
The answering time has not yet come.
My lord.
Let me hear him first. You just answer for a while that whether it was a suit, the other suit,
my lord.
Paragraph 12 suit.
Yes, my lord.
It is only between the two parties, that is your client and Indian Airlines, or anybody else is there.
It is between our client and Indian Airlines, my lord, but I'll still get a clarification.
Nobody else is there.
Shouldn't be, my lord. I'll still get a clarification.
Shouldn't be.
I'll get a clarification.
Interested.
My lord.
It is. I am interested.
Yes, my lord. Kindly give us, my lord, a minute's time. We'll just get the clarification. I shouldn't make a submission without knowing.
Absolutely.
I'll just.
Yes. Now take your seat. Yes, Mr. Ray.
So, my lordship has seen the prayers. Now 13.
That's why I asked. Show me the.
My lord, grateful, my lord.
Now 13.
13, my lord. The defendant number 1 by a letter dated 16 December 2005 demanded payment of the said dispute amount of such and such. On receipt of the letter, plaintiff had duly replied, followed by another letter. Well, and I'm not on that again between Indian Airlines and sorry, this is my letter. Demand payment of the said dispute amount of rupees 99 lakhs. Kindly seize this letter F.
Yes.
Page 41, my lord. 41, my lord.
The quantum is not telling. Take the quantum first line, paragraph 12, and take the quantum second line, paragraph 13.
No, my lord, he is referring to my letter, my lord.
No, I'm going to that letter.
My lord, the quantum is from my letter.
It's matching.
Acha, quantum from your letter. Yes, sir. Page.
Wrong, my lord. Matching.
Page
41, my lord.
41?
Oh, 57. In my application, my lord. Sorry.
57.
Yes, my lord. We have been advised by Indian Airlines. One kindly sees the wordings and sees paragraph 13, my lord. We have been advised by Indian Airlines.
Yes.
The amount of rupees 99,16,798 against adjustment done through BDR in the beginning of the fortnight, and that is BDR is not acceptable to them. So, the demand is being made on behalf of Indian Airlines. There is a reason why they did not annex the main agreement.
Good.
Oh.
It's only Indian Airlines. Only Indian Airlines.
Yes.
And there is a reason why they did not annex the original agreement which they are talking about.
Which agreement, sir?
And that is what I'll try to find out with your lordship together, my lord. If your lordship grants me that, my lord.
Which between whom?
That I will try and find out with your lordship, my lord. while reading the plaint, my lord. I believe that that is the agreement which we are talking about, my lord. It's the next paragraph. So, my lord, I'm not going to take.
No, you're pressing the letter. So placement
So,
of
my lord,
letter is over.
Over.
All.
It is on behalf of Indian Airlines. Your lordship must keep a note of that. First sentence, my lord.
All right.
Then
Next.
14, my lord.
14.
On 22nd December 2005, the defendant number 1 issued a notice of termination of the plaintiff's sales agency agreement with effect from 22nd January 2006.
This agreement between whom?
That is the most important thing, my lord.
January.
That is the most important thing. Later on, he says that this is between me and him.
I don't say that. They say that.
Yes.
My lord, I'll just take your lordship to that. My lord, just
Page, letter G, page
63, my lord. Or 63, my lord. We have been declaration of default. We have been advised by the BSP management that they have failed to make payment of sales made on the issue of traffic documents for sales or such. IITM member airlines have been advised of an indebtedness to them and have been instructed to deal with the approved location on a cash basis and withhold payment of commission on sales that they have effected on their behalf until further notice. On behalf of members, BSP management shall withdraw all standard traffic documents from the approved location and shall demand an immediate accounting and settlement of all amounts due upon the date of default. Furthermore, pursuant to the requirement IATA Passenger Sales Agency rules, acting as the authorized representative of the agency administrator, we hereby give you notice of termination of your sales agency agreement to take effect on 22nd January 2006. But may I just again read this? As the agency administrator, so as an agent, I am seeking for termination. Well, so two things. First, one of the agreement should be before your lordship. That subject to correction. Obviously, I have not been able to find out from this plaint. But at the end of the day, one thing is standard. Because my learned friend is also relying on this one, that I was acting as an agent. Then who was the principal? Who was the principal?
Indian Airlines.
But we don't know. The agreement will speak for itself.
No. If the agreement is between plaintiff and Indian Airlines, and if somebody talks of termination thereof, then he must have acted either on behalf of plaintiff or behalf of the defendant, on behalf of the.
But these are, may I just point it out, Malad? I had the occasion of appearing for my learned friends' clients also. Malad, these are agreements which are a bit special in nature.
I am not on that, Mr. Ray. Today, the application is that throw it out of the commercial list.
Yes, because Malad,
it doesn't speak for
now, Malad, that's why I taken your lordship agency.
It doesn't take away, it does not pray for dismissal or rejection. It's
no, that Malad, whichever I go, whichever place I go. I'm not on that, Malad. Now, Malad, why did I point out Malad 21? 21C 21. Agency agreement can be an agreement under the provisions of the commercial dispute, but it has to be related to the above.
Absolutely.
I say there is nothing of that sort here. That is first adjudication.
That cannot be simply, according to my view, as of now, subject to further hearing, you and him. It's a travel issue.
Malad, with humility, Malad, may I say this, Malad? if it's a tribal issue, this is again, this is not a case where your lordship will kindly appreciate, I'll be relying on certain judgments also, but if it's not a commercial dispute, even your lordship suo motu at the very beginning is supposed to
Order 7 rule
Order 7
11,
rule 11.
Absolutely.
Now, your lordship will have to see then from
and all.
Then your lordship will have to see from this plaint that they are making out a case that yes, it's a commercial issue. Where is the pleading?
Sir, if on a reading of the plaint,
yes,
the court finds it is a commercial dispute, there is nothing to say on the face of it. It is not a commercial dispute.
But again,
let me put it in this way: if on a reading of the plaint, it appears to the court that prima facie it is nothing, it cannot be said it is not a commercial dispute, then of course the suit shall stand for trial.
But I am saying on the face of the plaint, there's nothing to show that it is a commercial dispute.
That's right.
That is what I'm submitting,
Absolutely.
I say that it need not stand the trial because of two specific reasons. One is, there has been no disclosure, and it is, under the Commercial Codes Act that all documents are required to be disclosed. So if it is not disclosed, then your lordship will also, while dealing with it as to whether the agreement is commercial in nature or trying to find out prima facie finding of that, will also take into contention the agreement is not on record.
Mr. Ray, it doesn't say that an agreement cannot be an oral.
It does not plead that way,
No, I'm saying.
I cannot give them an inch,
No, not at
so,
all.
they do not plead it's an oral agreement.
Not required to.
They do not say it's
but to throw away a plaint.
Well, they have not said it's an oral agreement.
Must be. That's right. But the moment one says an agreement, the expression used agreement, if it is there in the plaint, does it
first of all, yes. Why I say this, kindly appreciates, an oral agreement has to be pleaded as oral agreement. There is no pleading to that effect. I cannot.
At the time of trial?
No, at this time.
No. Very well. Very well. Now, at the time of trial, they may fail. They may not be succeeded. There is no agreement at all because no written agreement pleaded, neither annexed or disclosed. So at least there is no written agreement. Fair enough. Whether oral or not, they may fail at the time of trial.
This is what I'm beseeching your lordship, we are not supposed to add to the plaint. We are not supposed to add to the plaint. The plaint nowhere says that it's an oral agreement. Kindly appreciates that. So I am not here to give them anything from my side. So, I would also beseech your lordship.
I'm talking about my job.
Your lordship will also not do that, because we are bound by the pleadings. Kindly,
Absolutely.
So,
bound by the pleadings.
And it is only agreement. So, kindly appreciates what is that they have said in the plaint. Because, today it is the duty of the court to throw away frivolous disputes of not commercial in nature. That is HON'BLE Sarabai. Again. So, that is why I'm seeking a lordship's indulgence here, when they say it's a sales agency agreement. Now, let's see what is the case they are making out. Let us see the case they are making out. Now, your lordship will kindly see 13.
Yes.
I have to go.
You don't use the reading glass?
Sorry,
You don't use the reading glass?
For some reason, I'm not very comfortable with. This is progressive. I'm not comfortable.
I'm also with progress. I'm also wearing a progressive.
I'm not at all comfortable. It's always darker than what I see with my regular eyes when I open my. Now I realize, another lordship, if your lordship remembers, in Court 11, he would always change his. Lordship remembers his spectacles.
No, I'm comfortable with progressive.
I'm not at all comfortable. I'm very uncomfortable when I'm climbing down stairs. 2 or 3 times, I'm nearly missed.
That is to start with. Then you get used to it.
I've been wearing for nearly 2-3 years, nothing's. Maybe because of my girth also, that could be a case because I cannot see down properly. No, this is. There's nothing to. This is the truth.
So many things to say. All right. Yes.
14, my lord. 22nd issued a notice of termination. Then 15.
Yes.
The true and correct facts of the case. The plaintiff by the letter stated the true and correct facts of the case. Said letter it would make its claim against Indian Airlines for damage before the appropriate forum. Can you kindly take this H, my lord?
H.
Page 64. Huh? Page 64.
Oh, acha, annexure.
Annexure H, my lord. Sorry, my lord.
Yes.
Talks about the BDR, my lord, issued by Indian Airlines. Then sees, my lord, please note that in our various discussions corresponding with Indian Airlines, Kolkata officials, including the regional director, Eastern region, we explained to them agreement dated 15 December was subject to uninterrupted and unconditional support required from Indian Airlines. So they're talking about the Indian Airlines part. Then, my lord, tsunami, then kindly straight away goes. Sorry. And this, as a matter of fact, I must.
You sent for that Ambalal once. Ask your junior to bring a printout.
Ambalal, tell me yes. And there are a couple of other judgments also, my lord.
No, there is one paragraph subject to be corrected by both of you in Ambalal.
My lord.
That if the suit is also not framed, in a way it ought to have been framed. Is it there? Maybe irrespective of its classification, whether commercial or not. Because that's the first principles of law. That's the irrespective of commercial or non-commercial, that if a suit is not framed in a way it should be or it ought to have been.
To invoke that jurisdiction. To invoke that jurisdiction.
No, that's separate. But I'm saying, suppose X versus Y, a plaintiff is there. Now, X files, the same plaintiff files a second suit. You also listen to this.
Against Y.
Against Y. XZ. XY is the first suit. XZ is the second suit. But the cause of actions are such. Joinder. Two separate trials.
Then your lordship,
the moment it is X versus Y, one suit, one trial.
But your lordship had the power of consideration.
Listen.
My lord.
The moment it is X versus Z, second trial.
My lord.
Independent suits, independent trial. But the cause of actions are, if pleaded, to be intertwined. Then why one suit, two suit, three suit? Right?
Absolutely. Absolutely.
Which is the prior suit?
That one. Indian Airlines.
Indian Airlines.
That's why it's pleaded in this suit.
করবে কি করে? ঠিক প্রেয়ারটা দেবে কোত্থেকে? হয়তো। ঠিক।
Now, my lord. Yes. Now, my lord, kindly sees. Let us go back to the plaintiff again.
80. We are at 16.
65 I have shown. Now, para 16, my lord.
Yes.
The agency administrator. Then defendant number 1, without considering the statements contained in the plaintiff letter, issued a notice on 1st February terminating the plaintiff's sales change agreement with immediate effect. This is I.
Page?
This is at page 68.
Not to get involved.
The sales agency agreement, Mr. Bagh, between whom?
Sales agency agreement was between Indian Airlines and, my lord, the plaintiff. And that is why...
Nobody else is there.
No, my lord. And I'll indicate when my chance comes, my lord, I'll indicate why, my lord, these are absolutely separate cause of actions. In fact, the paragraph which will now come will indicate that.
Well, then I'll take my matter from what he has said. So now I don't have to labor there. So he's saying it's an agreement between the Indian Airlines,
Bipartite.
Indian Airlines and him. So, my lord, I did not have a right to terminate it. One. Second, he's saying, my lord, this has made my life a bit easier. My lord, the next he's saying, my lord, kind of very quickly, my lord, if I lordship take your lordship, my lord, kindly sees paragraph 16, 17, 18, 19, 20. He says, I terminated. Then he says, review he has sought from me. I have not given effect to the review. I said, no review, nothing. Then, my lord, he has written down the clauses, para 19, kindly see page 25. Written down the clauses.
Page?
Page 25 onwards, my lord.
To show what?
My lord, that why did I terminate? How could I terminate?
All right, next.
But he admits that I am not a party to the agreement. So maximum I couldn't have a right of terminating. I didn't have a right of terminating.
That's why I asked that question. That
prayer in the suit. Can we record this up?
all right. Wait for you.
No, I.
Next.
Then, my lord, kindly sees clearing bank and everything going on. Agency administration aware. Then, my lord, continues 3, 4, 5.
Wait. The kindly come to paragraph 21.
Yes, I'm on there, my lord. Page 28. Plaintiff therefore states that pending resolution of the dispute regarding the claim of Indian Airlines, which is the subject matter of civil suit, defendant number 1 cannot declare the plaintiff as a defaulter and cannot take any action on that basis. So he says first that there is no agreement, but I've made him a defaulter. Therefore, he says, para 22, my notice of termination is bad. Once he says that I am not a party to an agreement, it's not a dispute arising out of an agreement. At the maximum, it would be, a case where I have caused a mischief against him. He is wanting a declaration to that extent. Then he talks about an insurance policy which has been taken out. Para 24. The defendant number 1 has now invoked the insurance policy and claimed a sum of rupees 78 lakhs.
It is between him and insurance company.
No, between me and the insurance.
That's my cause of action.
No. Defendant number 1 has now invoked
insurance policy.
You are the insured.
Yes.
You are the insured.
Yes. And claimed a sum of rupees 78 lakhs.
So he may at best claim here that you have no right to do that.
Yes. It is, again, if the insurance is in my name, who is he to prevent it? The insurance policy will, the insurance
if you are the beneficiary,
you cannot.
If you are the beneficiary, you will get it.
Bank guarantee.
Yes, if he will get it.
That is, so who is he to say?
If the terms are satisfied, you will get it.
I'll get it. Then, can you see? Lodged by the claim. The claim lodged is illegal.
28.
Claim lodged is illegal.
Right.
Then someone has asked for return of non-availed tickets. He's saying that is also arbitrary. Then he says it's a case of fraud. Fraud, with humility, can be intra-agreement or beyond an agreement.
Yes.
Kindly sees.
Bring Ambalal at 2 o'clock. No.
May I just request this,
No.
Kindly.
I will complete, sir.
My request. Only one request, Mr. Banerjee will continue. If your lordship kindly gives me leave for 15 minutes. Hey, Kodishna, please.
That is all
I'll
right.
just come back, my lord. I'll come back. and
That
do it.
is always, that is always. Even I can, even if your junior, if the learned youngest junior does, I'm absolutely.
Well, kindly allows that. I'll be back by 10 minutes, man. Kindly gives
That
me
is all right.
There's a partner matter. I'm also there in a partner. I'm very sorry, man.
That is all
Just come and come back, man. By 2:10:15, I'll be here, man.
No problem.
Very grateful.
That
Sorry
is all
about it.
right.
I'm sorry.
No, that is all right. But my
No, man. Let's
thinking
come and
is-
do the matter, man.
yes, my thinking is that if I have taken up a matter,
No, I'll come and do the matter, man.
spared so much of time. All of us, we have spared so much of
No,
time.
man. Definitely.
Rightly or wrongly, I must
Whichever
conclude
way,
it.
man. Definitely, man.
I must conclude it.
Definitely.
আরে রাখা নেই। Yes.
One, may I kindly continue with the plaint, my lord? Well, I was at page 28.
Yes.
Para 21. The plaintiff therefore states that pending resolution of the disputes regarding the claim of the Indian Airlines, subject matter civil suit, the defendant number 1 cannot declare the plaintiff as a defaulter and cannot take any action on that basis. In the circumstances, plaintiff states the notice of termination of the plaintiff's sales agency agreement is illegal, null and void. The same is left outstanding called substantial prejudice.
In the circumstance, plaintiff states that the notice of termination of the plaintiff's
sale agency agreement
are
illegal, null and void, and same is left outstanding will cause substantial prejudice. Then 23, it may be noted that Indian Airlines have already filed a counterclaim on 15th May 2006, claiming a sum of rupees 99 lakhs against the plaintiff and claim of which is sub judice. The plaintiff has caused an insurance policy taken out in favor of the defendant number 1. Insurance issued by the defendant number 1 has now invoked the insurance policy para 25 and claimed a sum of rupees 78 lakhs. The said claim lodged by the defendant under policy is illegal. Then, my lord, a notice issued by one Rohit Kumar for return of non-avail tickets, that is arbitrary and wrongful. Now 28, my lord, kindly, may I just place this. Plaintiff states that the claim lodged by the defendant number 1 with the defendant number 2 is illegal, null and void, and also fraudulent. My lord, kindly sees. The claim lodged by the defendant number 1 with the defendant number 2 is illegal and null and void and fraudulent. Not with regard to him. The said
not with regard to
the plaintiff.
Yes. Between the two defendants.
The said policy of 18th November covers financial loss suffered during the period of 1st December till 13th month. 13 months thereafter. In the present case, financial loss, if any.
Required. You skip over.
No, no,
because the main paragraph shows it's an interdependent claims. Painting is.
No, there are certain things which is written in these paragraphs also. Man, kindly allows me, my lord.
Yes, yes.
Kindly sees just A 28A, my lord. Last 3 lines from the agency debit memo. 28A, 3 lines. From the agency debit memo, it would appear that the claim of Indian Airlines is for the period 15 December to 2nd July, as such the claim is not covered by the said insurance policy. Then the defendant number 1 has not sustained or incurred any financial loss during the period of insurance or at all. It is not the case that the defendant number 1 that has paid Indian Airlines any sum of money or otherwise sustained or incurred any financial loss when in default of the plaintiff. The claim of Indian Airlines against the plaintiff and the plaintiff's claim against the Indian Airlines is the subject matter of CS number such and such. So their diverse claims are subject matter of CS number such and such. The earlier suit. Defendant number 1's declaration of the plaintiff as a defaulter and the termination of the plaintiff's sale agency agreement is illegal, null and void for the reasons as stated here and below. The claim of Indian Airlines anyhow does not arise out of traffic documents sold by the plaintiff on Indian Airlines route. Claim is for recovery of extra incentive already made available to the plaintiff has no connection with the issuance of travel documents. Defendant number 1, knowing very well that no money is due and payable by the plaintiff to the defendant number 1 and the defendant number 1's claim is not covered by the insurance policy, it means fraudulent claim, object of unjustly enriching himself. So, whenever we are talking about these things, this is a claim lodged under the insurance policy. C.
828C.
The defendant number 1's declaration. Your lordship is on that one. The defendant number 1's declaration of the plaintiff as a defaulter and termination of the plaintiff's sale agency agreement is illegal, null and void for the reasons as stated here and below. There is no reason for that. But I think that's a cut copy paste that happens. But what is
there in the plaint?
Yes. But very important is, my learned friend has just said, your lordship asked, he said it's an agreement between Indian Airlines and the plaintiff. He doesn't mention me. Then, kindly sees 29. claim lodged by the defendant number 1 with the defendant number 2 against insurance policy is illegal, null and void, and if allowed, the same will cause substantial loss to the plaintiff. But this loss cannot be a contractual loss, my lord, obviously. Then in that case, defendant number 1 would take steps for recovery of the claim from the plaintiff. I think it's a typographical error, my lord. It was defendant number 2 who would take steps against the plaintiff, not 1. Because 1 gets his money, 2, since he pays money, he will claim it from the plaintiff. Now, my lord, consequently, the plaintiff will suffer substantial loss and damage. The plaintiff have come to learn that defendant number 2 is taking steps for making payment against the claim lodged by the defendant number 1. Appears from the letter of that surveyor, my lord. Then, my lord, 31. Defendant number 1 has illegally and unlawfully declared the plaintiff defaulter and terminate the sales agency.
Page.
My lord, this is para 31, page 32. The defendant number 1 has illegally and unlawfully declared the plaintiff defaulter and terminate the sales agency. As a result whereof, the plaintiff has suffered substantial loss and damage, particulars whereof stated herein below. Now, kindly see how he is quantifying. Plaintiff has not been able to recover from its customer sales proceeds of the tickets already sold prior to the declaration of defaulter on 22nd December. The total amount of claim the plaintiff has not been able to recover, which is reasonably assessed to get 2.5 crores. So he's talking about complete loss vis-a-vis what he has not been able to give to a third party. Then B, plaintiff's valuable goodwill and reputation has been completely lost. But again, it's on a question of damages, loss and damages, and not on a contractual dispute. Goodwill, mallet. That's why we also now it's standard manner that goodwill cannot also go on before an arbitration. Then mallet kindly sees C, because of the termination of the plaintiff's sale agency agreement and consequential non-realization of sale proceeds of tickets, the other airlines have made claims against the plaintiff. So that's under their agreement. So even if he wants to make a claim against me because of that, that would be obviously in the nature of
any injunction obtained on this plaint?
Injunction, I'm not aware,
in the second plaint?
Not to my knowledge, no,
all right. Yes.
Now kindly see 32. The total loss suffered by the plaintiff for the unlawful conduct of the defendant number 1 will assess at rupees 5 crores. So, conduct is what is being assailed now. Then the plaintiff is entitled to a decree for a sum of rupees 5 crores. Special equity arises in favor of the plaintiff not to make any payment against the said insurance policy. So once he is asking for equity, obviously he is not entitled to under any contract. He admits to that. He is asking for special equity. He is not trying to enforce any contractual obligations here for the insurance policy. Then, 36 at page 34 is very important. The sales agency agreement was terminated by the defendant number 1 by notices dated such and such and such and such, which served on the plaintiff at 2 Ganesh Chandra Avenue. The sales agency agreement, now kindly see, between the plaintiff and the defendant number 1. Now, which to take, I do not know.
What is this? Sales agency between the plaintiff and the defendant
number 1 was performed within. Then the passenger sales agency agreement has been executed by the plaintiff at 2 Ganesh Chandra Avenue.
Mr. Mark, what is this?
Between the plaintiff and the defendant number 1.
The sales agency agreement between plaintiff and the defendant number 1 was performed from both within and outside.
I'll indicate, because this agreement, what is being submitted, is not clearly in the nature of what is being submitted. It's there in the pleadings. I'll come back to that, my lord.
You said sales agreement between the plaintiff and the Indian Airlines.
Indeed.
Then what
And
is
this
defendant number?
IATA is an umbrella organization. The moment, my lord, an agreement is signed by.
All right.
That's why I'll make that submission.
And that is why I told you, Lordship, my lord. Now kindly see, passenger sales agency agreement has been executed by the plaintiff at 2 Ganesh Avenue and on behalf of the defendant number 1 at Singapore. So, my lord, the question of any oral agreement, no more defense.
All right. Not that.
I mean, it's in execution.
All right. Next.
Execution means signing, he's saying. The agreement was concluded and came into existence. One kindly sees. Upon the plaintiff's execution, 2 Ganesh Avenue, in as much as the defendant one had signed the agreement earlier. Just after that.
Passenger sales agreement
No,
between.
passenger sales. It's just after Singapore, which is outside the jurisdiction.
No. The agreement was concluded and came into existence upon plaintiff's execution at Ganesh Chandra Avenue. Defendant number 1 has signed.
So, if signing cannot be an oral agreement, now, breaches committed by the defendant numbers at their offices has caused loss and damage to the plaintiff. And within the jurisdiction of this court, and the said breaches arise out of the terms and conditions of the agreement executed to Ganesh Chandra Avenue. Now, once he says.
But I should pause you for a moment.
I am pausing.
And I should
pause.
No,
I should pause.
Who will pause? I should request my learned friend to pause here. In the other papers we find, Lord, you're being instructed by Mr.
Yes.
Lord, my learned senior friend's advocate on record had issued a letter on 7th of April 2014 annexing the passenger sales agency agreement. But you're not showing it, but then this is not a commercial suit. It shows it is signed.
I'm not showing it.
It is signed between International Air Transport Association and Jinanai Travels. And IATA member, as a member, Indian Airlines is a party. As a member of IATA. And this is not a commercial suit from the very beginning. So, my lord, my right to disclose additional documents is not gone. It can't. Because it's transferred in the month of April. I'll make those submissions, my lord. Because it was not there, I couldn't make that submission. Now it is there with us, the agreement. So
it's not on record.
It's not on record, my lord. And this is not a commercial suit from the beginning.
All right,
so
next.
That is the reason.
Since Mr. Bagh has read from that, my lord, I think he is not aware of the agreement because he should have. No, he's not aware. He's not aware because, my lord, that is why it will show IATA was acting as the agent.
So IATA was a signatory to that agreement?
As an agent. Agent of all airlines, my lord.
So it was executed by IATA
as an
on
agent.
behalf of airlines.
All airlines. All airlines.
So
well, what happens?
Party to that.
As an agent.
Maybe, but a party to that agreement.
Yes.
So it was a tripartite agreement.
No, it is not. My lord, it is an agreement between, my lord, each of the airlines with these travel agents, my lord, and my lord, as he rightfully said there, as an umbrella that not every airline has to sign. IATA has agents of all these airlines because IATA covers all the airlines, my lord.
That's right.
So as the agent signs, so whenever he's signing as Indian Airlines or KLM or whatever it is. Now this is not on record at this moment. So I am only proceeding on the basis of what is written in the plaint.
We all have to.
Whether it is making out a commercial suit or not. Because at the very end, at the place where it is been executed, it specifically stated it's at the agent. Now, kindly see, my lord. Then page 35, para 37. And this clause 12 leave. It factor the ponchata cost with the jet. 1865 nahi? Whatever, tolko to bochi nahi. Decree for rupees 5 crores as pleaded in 31 and 32. Mana 31 and 32 mana has shown, my lord.
Why don't you tell the learned draftsman?
I don't know who's the draftsman. Sorry. But we both have to tell.
You both are privy to that.
As an agent. I did not notice that, but I'm sorry.
I also did not. But suddenly I noticed. All right.
Now, my lord, so 31 and 32. 31, the claim which has been made, my lord, 31A, I have shown, my lord, has not been able to recover from its customers' sales prices of the tickets. So, damages because of he has not been able to recover from some other customer, not under any sales agency agreement. Then 31. I have shown, my lord, other claims made by other airlines. For that, he is claiming damages against me. Then, my lord, he has referred to 32. 32 is basically the quantification of unlawful conduct and therefore 5 crores. Now, B, notices dated, says in other documents connection with the said declaration as defaulter and termination of the sales agency in the plaintiff be adjudged or be delivered up and cancelled. So, he is asking for delivery of the notice of cancellation. Claim lodged by the C, defendant number 1 with the defendant number 2 against the insurance policy be adjudged and delivered up and cancelled. Mine against interdefendants cannot be a claim under commercial dispute. D, perpetual injunction restrains defendants from making any payment to the defendant number 1 against the insurance policy. D1, D2. E, my lord, injunction restrains defendant number 1 from treating the plaintiff as a defaulter. And F, perpetual injunction restraining the defendant number 1 at agents and servants from interfering with the plaintiff's function as a passenger sales agent of IATA. So therefore, my lord, his suit primarily, my lord, there are 2 parts. One, he's saying, I have signed. I don't know whether he's agreeing that I've signed as an agent. If I sign as an agent, my lord, obviously the principal has to be on record. The principal is not on record, my lord. So, my lord, otherwise the plaint will fall. That's a different thing altogether. I'll take out separate application. 230, my lord, is glaring at them of the Contract Act. You have to make it a party. Other than that, my lord, let us say I am the principal. I am the principal. My lord, what kind of an agreement is it? Under which provision of 21C does it fall? That is what the plaint has to point out. The plaint maximum says it's a passenger sales agency agreement. Now, my lord, kindly see, I pointed out to your lordship, 21C21 makes it a mandate rather that the agency must be related to anything prior to 21C1 to 20. That has not been pleaded anywhere. Rather, the agreement is not before your lordship also. The agreement needs to be before your lordship, so that your lordship can see and say, yes, this is a commercial dispute. That's a primary requirement. Whenever, my lord, your lordships are assuming jurisdiction, your lordships will assume jurisdiction on the basis of something. Now, what is there in a commercial suit? Commercial suit requires that all documents will be on record. Now, if all documents are not on record, then the pleadings will make it a point that it's a commercial dispute. Even for that matter, my lord, if your lordship looks at section 15 transfer, that also will be on the basis of documents. Fundamental question only one. কোথায় ছিলাম খুঁজে পাচ্ছি না রিপ্লাই তো বলেছে So, my lord, this is the situation. Now, the question is, my lord, whether 2 parties can impose some jurisdiction on a court which the court doesn't have. And that is obvious. It's absolute. You cannot. So the point remains that the point which my learned friend was saying, that I have taken this point, I had been a privy to that, my lord, that I don't think goes this way or that
Show me the judgment.
Yes, now the HON'BLE Sarabai judgment, my lord.
ये कौन तारीख?
আরেকটা বেটার নেই I will kindly mind your lordship's Fingers, my lord, the pin, my lord. Finds your fingers, your lordship. The other one was worse. So
strategic move. You are for the applicant. Yes.
for the defendant applicant, my lord. Now, my lord will kindly take this judgment, my lord. And my lord will kindly come to paragraph 13. The learned senior advocate, my lord has got that one.
Proceed.
For the applicant would, however, contend that a strict interpretation, as in the case of taxing statutes, would not be appropriate in the instance case where the issue relates to jurisdiction. In that regard, the learned senior advocate has referred to the statement of objection for which the Commercial Courts Act is enacted so as to provide speedy disposal of high-value commercial disputes, so as to create the positive image to the investors' world about the independent and responsive Indian legal system. Hence, he contends that a purposive interpretation be made. It is contended that the wider purport and meaning is to be assigned while entertaining the suit and considering the dispute to be a commercial dispute. Having taken note of the submission, we feel that the very purpose for which the Act was enacted would be defeated if every other suit merely because it's filed before the commercial court is entertained. This is for the reason that the suits which are not actually dealing to commercial dispute or being filed merely because of the high value of the intention of seeking early disposal would only clog the system and block the way for genuine commercial disputes which may have to be entertained by the commercial courts as intended by the lawmakers. In commercial disputes defined, a special procedure is provided for class of litigation, and a strict procedure will have to be followed to entertain only that class of litigation in that jurisdiction. If the same is strictly interpreted, it is not as if those excluded will be non-suited without any remedy. The excluded class of litigation will in any event be entertained in the ordinary civil courts wherein the remedy has always existed. In that view, it is also necessary to carefully examine, entertain only disputes that actually answers the definition commercial dispute. At 14, my lord. In that view, it is also necessary to carefully examine and entertain only disputes which actually answers the definition commercial dispute as provided under the Act. In the instant case already taken note, neither of the agreement between the parties refers to the nature of the immovable property being exclusively used for trade or commerce as on the date of the agreement, nor is there any pleading to that effect in the plaint. So, my lord, plaint and the agreement
reading together.
Yes, the agreement is not before your lordship. And the plaint is neither here nor there, if I may say so, because the plaint nowhere describes what is the scope of the agreement. Today, Mr. Bagh, on his own volition, obviously saying the right thing, my lord. He is saying that the agreement has such a nature, there's an umbrella, IIT is the umbrella under which all the airlines are. But this your lordship will not find in the pleadings. It's nowhere there. So that is what I'm on, that whether your lordships, are we only restricted to that? And how strict need we be? Ammalal says we have to be very strict. And these are the two things which has to be looked into. The agreement and the pleadings. Further, the very relief sought in the suit is for the execution of the mortgage deed, which is in the nature of specific performance of the terms of memorandum of understanding, without reference to nature of the use of the immovable property in trade or commerce as on the date of the suit. But another question arises here, my lord, what is the effect? Even if I take Mr. Bagh's submissions, my lord, and also the pleadings, my lord, admittedly, my lord, it is half-half. It's not a simplicity of commercial suit because obviously disputes between defendant number 1 and 2 and no claims to be made with the insurance policy. But these cannot be under any agreement. These are not under any agreement. Then what is the effect? Commercial Disputes Act only refers that it will not be otherwise. Sorry, my lord, I keep forgetting the language. My lord, kindly gives me a second minute. But in under 2.1, there's an explanation.
Which book you are referring to?
The commercial disputes, settlement.
Pick one in your hand.
This. This is a own, not mine, my peon's compilation.
Acha. Compilation of?
Of acts which I call upon him to produce most of the time, so he has made this one.
That's why I'm saying such a thick book on commercial deal.
It contains a relevant required acts, Malad.
Yes.
So, Malad will kindly see after 2, there's an explanation. After 2.1c 22, after that there's an explanation. A commercial dispute shall not cease to be a commercial dispute merely because. So this is the expanse of where commercial disputes and which are not commercial disputes are joined, which is, it also involves action for recovery of immovable property or for realization of monies out of immovable property given as security, or involves any other relief pertaining to immovable property. And B, one of the contract parties is the state or any of its agencies or a private body carrying out public functions. So this is the only case where disputes not commercial but joined in a commercial suit will not make it a non-commercial suit. Otherwise, if you go very strictly, Malad, there wouldn't be even joinder of 2 causes of action. Now, Malad, may I come back to Ambalal Sarabai once more, Malad? Kindly see para 24. Your Lordship will find Justice Bhanumati Malad recording reasons, where Malad will kindly see Malad para 24 onwards, 2.1c is set out. Then Malad para 25. Internal page 599, Malad, Lacetum. As noted above, clause 1 of section 2 of the Act defines specified value. In relation to a commercial dispute shall mean the value of the subject matter in respect of suit as determined according with section 12, which shall not be less than 3 lakhs or such higher value, as when it's notified by the central government. Section 12 provides for criteria of valuation of suit, application, appeal. Then, a matter will fall under the jurisdiction of commercial court or the commercial division on the following factors. It shall be a commercial dispute within the meaning of section 2.1c of the Act. 2.1c does not talk about any joinders, Malad, save and except the explanation, and it's specific. With regard to agency, Malad, it has to be in cases of 1 to 20, which has not been pleaded. Your Lordship will also not get that from persuasive reading of the plaint, Malad. Then such commercial disputes have a specified value, and it will be above 5 crores because I cannot stand in the way of that. Then, as per section 11 of the Act, notwithstanding anything contained in the Act, a commercial court shall not entertain or decide any suit relating to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or impliedly barred under any other law at the time being enforced. So that is neither here nor there. Then, Malad, section 15. Malad, he was talking about the transfer. Malad, if it's a transfer, then timelines will not apply. Malad, that is a different thing altogether. What I am on, Malad, today, that the plaint does not contain the
disputes which can be called as commercial.
Commercial, and your Lordship could have made a reading of it if the agreement was here before your Lordship.
Which is a mandatory disclosure.
It is. Not only under the Commercial Codes Act, Malad. If your Lordship
Order
says,
7.
Order 7 is clear. Clear. Then my lord kindly sees 29. And 30, my lord, 30. 31, my lord, statement of objects and everything has been shown. (13, 14), everything, my lord, discussed. Then, my lord, 33. As per section 16 of the Act, the provisions of the Code of Civil Procedure amended under the Act shall apply in the trial of suit in respect of a commercial dispute of a specified value. Therefore, my lord, the entirety of the amendment has now started applying. So when it has become applicable, my lord, then I am saying, my lord, it becomes a mandate that you produce the agreement. Then, my lord, 34. Rather 35. 35, my lord, in between Placidum E and F. The intent of the legislature seems to have a procedure which expedites the disposal of commercial disputes and thus creates a positive para 35.
Yes.
In between Placidum E and F, my lord.
There's no Placidum.
On the right, my lord, it's not there. I'm so sorry, my lord. My lord, it's the last 4 lines of para 35.
The intent.
The intent, my lord.
Read.
The intent of the legislature seems to be to have a procedure which expedites the disposal of commercial disputes and thus creates a positive environment for investment and development and make India an attractive place to do business. A perusal of the statements and various amendments of civil procedure, insertion of new laws and everything, my lord, that has been enacted for the purpose of providing an early disposal of high-value commercial disputes. Our purposive interpretation of the statement of objects and reasons and various amendments to the CPC leaves no doubt that the provisions of the Act requires to be strictly construed.
So, strict construction.
Yes.
Like taxing statute.
Yes.
Ultimately.
No liberal approach. If the provisions are given a liberal interpretation, object behind constitution of commercial disputes, putting the matter on fast track and speedy resolution of commercial disputes will be defeated. Take a closer look at the objects on reasons words such as early and speedy have been incorporated and reiterated. Objects shall be fulfilled only if the provisions of the Act are interpreted in a narrow sense and not hampered by the usual procedural delays plaguing our traditional legal system. Then, my lord, it goes specifically to the interpretation of clause 21C7. So I'm not going there, my lord. Then, my lord, kindly comes to para 40, my lord. Ujwale Raje Gaikar was discussed, my lord. It's a suit instituted for declaration of a sale deed of 17.76 crores.
No, I understood. Now your argument is strictly construe the definition of commercial dispute and then apply it on the basis of the averments in the plate.
Yes. Now, my lord, why I want to show one other document, my lord. And kindly sees their opposition. This is an opposition of 19 December 2024, my lord. I think it has been filed before your lordship. Yes. Well, it kindly takes para 3 onwards, my lord. It is a batch application nipped in the bud. Delay, undefended, no right to oppose any prayer. Then, my lord, Kindly sees E, my lord. This is what my learned friend was obviously harping on, my lord, while saying that by an order of 1st March, Honorable Court was pleased to transfer the instant suit to commercial in the observation that the dispute involved in the suit was commercial in nature. But note that although the defendant number 1 was represented on the said date, he raised no objection to such transfer. It is only on after a period of more than 4 months such and such has taken place. Therefore, there is undue delay. This is what he says had happened on that day. But I say, man, there cannot be a stubborn. It's wrong. It's no use proceeding in your lordship's jurisdiction, and thereafter getting a decree, Malad, which will neither benefit him or me, Malad. Then Malad kindly sees F is some attainment of finality, Malad. I'm not on that. G, page 4. Instant suit relates to the illegal termination of the plaintiff sales agency agreement by a notice dated such and such. As such, disputes in the suits are squarely covered under 21C. Malad, the second chance at the cherry, Malad, bite of the cherry, but does not say which part of 21C. Because once, Malad, I am assailing that there is nothing there under 21C, Malad, at least somewhere. Which part of 21C? Because, Malad, if we go by the wording of the agreement, Malad, it says agency agreement. If I can take it at the maximum, Malad, though it's not before your lordship's Malad. Then, Malad, talks about the specified value having been overcome, Malad, not a problem. Now, kindly sees H, 4, page 4H. That the subject matter in instant suit in a nutshell is that the defendant number 1 by a notice of February 1st terminated the plaintiff sales agency agreement on the basis of that the plaintiff was an alleged defaulter in as well not meeting the targets in view of the agreement of the plaintiff with Indian Airlines. And kindly sees, not meeting the targets in view of the agreement of the plaintiff with Indian Airlines. In view of the dispute between the claim of Indian Airlines and the plaintiff, a separate suit is pending adjudication before this court. And as such, before the resolution of the disputes regarding the claim of Indian Airlines, defendant number 1 could not have any basis to declare the plaintiff as a defaulter. So defaulter, he does not say under which provision he has been declared a defaulter, but I have declared him a defaulter. That the action defendant number 1 in declaring the plaintiff as a defaulter is premature. And the same is subject matter of CS number 23 of 2006. So the defaulter point is before CS number 23, he's saying. Not here in this suit. Unlike what he has said in the plaint. Then, my lord, not obligated to make any payments to defendant number 1 as the payment of dues from the Indian Airlines arose out of an independent contract which existed with the plaintiff and Indian Airlines. No action could have been taken by the defendant number 1 for terminating the plaintiff's sale agency agreement. And lastly, my lord, 5L, that the disputes in the instant suit arose out of the plaintiff's sale agency agreement that the plaintiff had with the defendant number 1. So again says now that he has an agreement with the defendant number 1. And the relation of the plaintiff with the defendant number 1 was completely commercial in nature. And the disputes thereof are squarely covered under 21C.
So had that original agreement between the plaintiff and the Indian Airlines been there, the question of this alleged agreement between plaintiff and defendant number 1 herein would not have been there?
No, wouldn't have been there.
Had the original agreement, let's say, the agreement between plaintiff and the Indian Airlines, which is the subject matter of the first suit, let's call it first suit, is there, automatically the agreement he is alleging in this plaint would not have been there first.
According to his submissions.
First,
yes, my lord.
First.
No, my lord, I have to deal with his submissions and what is specifically pleaded in the. That's why, yes, that is one. Yes, my lord.
One. Secondly, the adjudication of that suit, an independent adjudication, and an independent adjudication in this suit, what would be the result?
But according to his plaint, when I really
let us go
according to his plaint, he's saying that it's premature. So my action is premature. So that has to be first disposed of, and then only I can terminate him. Hold him as a defaulter, terminate.
Terminate, not terminate.
So now the scope would be, my lord, a declaration to that effect that this suit should not proceed without disposal of that suit. According to their suit.
I'm going by their plaint only.
Their plaint, if we take their plaint, if their case is taken, they say that it is being adjudicated, my action is premature, and since my action is premature, it is null and void, and I had some bad intentions. So basically, it's the first suit he's talking about, that which needs to be disposed of. And here in the reply, he says, no, it's an independent contract. For the first time, he says that.
All right.
That is whatever is there.
That's all.
Well, yes, I don't have any further submissions, and obviously subject to whatever.
So what if he cites any decisions? Of course, you will get an opportunity to deal with 100%. Don't you think you will get?
Yes, I know I will get. If I don't get, at least let my junior have that.
Of course, they will get. I mean, you means your side will get an opportunity. The captain of the team.
But I know the last one I did not go because I'm before your lordship partner. Now this one is a division-based partner. I have to go down. That is a kindly excuse me, they are here.
Time is very short today also.
I know, but I've got a matter at 3 o'clock fixed.
No, I'm not on that. So let me.
I'm sure he'll complete in 1 minute. He'll complete.
Let me
brother
hear
of
him.
mine, I'm only interested in taking his watch over one, and I've told him that if he wins, I take the watch.
Let him hear him now.
But may I take a watch?
Yes, and if he cites any judgments, of course, I will grant your team to get a.
Very grateful.
But I will not cite judgments.
Oh, that's great. Then I'm through. Through to the extent that I don't have to make any further submission.
You don't have to. Yes, take the botheration to come here.
Yes, I'm very grateful.
Yes, so it is a botheration for you.
But kindly does not put me in such situations.
All right. Thank you, Mr.
I'm very grateful.
Yes, Mr. Parr.
Well, very briefly before I start.
Sir, concentrate your submissions on your plaint, not beyond that.
But first, let me concentrate. May I first submit on the premise of what the petition is, which they have filed. They have argued something in the nature of Order 7, Rule 11. But the petition, VA8, is only for recalling of an order. Nothing else. The petition,
which means he is arguing that send this suit before
non-commercial division, not commercial. That's all. Nothing else.
That's all.
And all that has been submitted with regard to 21C. Why in affidavit we have not indicated which particular provision under 21C? That's because in their petition they have just made it
not required.
And they have not indicated that under 21C which provision would not apply. They've said 21C blanket.
Absolutely.
It can't be applicable to these
doesn't
facts.
attract.
Correct. Doesn't attract. Now I'll start from there and I'll show that this is absolutely a commercial division matter. It involves a commercial dispute under 21C. And that is the reason why on that day when the matter was moved on 1st of March 2024, not in our presence, we were not there. The name records that my learned friends were there. And they were present. I take it that it was, of course, discussed in the court. And then the matter was relegated to the commercial division. All those submissions that even with an agreement,
I have a very short question first. Answer to that. Show me your plaint in the first suit.
That's not part of the records. I don't.
Doesn't matter. It's part of the record, of course, not in this application. Show it to me.
I do not have it, Milord, today. In fact, I requested for it, Milord, during the break. I couldn't get it. They've not been able to.
But I require that plaint, copy of the plaint.
In case, Milord, it is required, I'll come back. But today, I don't think it will be required. I'll indicate.
I have a very short question.
My lord.
What is your cause of action in that?
Very grateful. That's indicated here, and kindly permit me to take your lordship to that.
In that plaint?
In that plaint.
Show me.
In that plaint, I'll come to that. But kindly give me 2 minutes before I come to that. Sir, there in the plaint.
Please
I'll
ask, no, first satisfy my query.
My lord, kindly take up page 6 of the plaint. My lord,
Yes.
kindly permit me to address your lordship from the plaint.
Yes, running
Page
page,
6.
running page.
Running page 6, my lord, paragraph 12.
No, your plaint starts from 17.
My lord, I'm reading from the plaint, my lord.
Plaint
From the
starts from 17. Their application.
my lord, kindly take up the plaint, my lord, from my plaint, not from their application.
Plaint page.
My lord, page
So
5.
there
Very well.
their
Paragraph
application.
12. Paragraph 12.
Yes.
It will be running page koto that. Internal page to that, na? Page 21, running page 21. It's because I'm only going to rely on the plane. That is why I'm placing my submission. The pages would not match, my lord, because your lordship is with the
Come on,
application.
tell me your paragraph.
My lord, paragraph 12.
Wait. Paragraph 12.
Page 21.
Wait.
My lord. To first answer your lordship's query.
Yes.
The claim of 99 lakhs odd by Indian Airlines Limited is illegal and not in terms of the agreement between the plaintiff and Indian Airlines Limited, for which purpose the plaintiff has already filed a suit being CS so-and-so. In this honorable court praying for the following reliefs. Over the page, my lord. Decree for 10 crores pleaded in paragraph 34 herein, and in the alternative, an inquiry into damages and decree for such sum as may be found.
Answer to my query on this paragraph.
My lord.
So had this, according to you,
my lord,
illegal claim not been there, had this illegal claim of Indian Airlines not being there, there would not have been any occasion to file your first suit?
Indeed, my lord.
Indeed.
There are two illegal claims, my lord. One is a termination by them.
Termination by?
By Indian Airlines.
Correct.
That's a separate termination, my lord. And there is a termination and there is a demand raised by Indian Airlines.
So these are
separate
the two?
cause of action.
Very well. Two?
Yes, my lord. Kindly see the next. The reason is, my lord, the next paragraph.
Sir,
the next,
please
I'm sorry.
answer to my query.
My lord.
Had the termination not been there,
my lord,
the question of demand would not have arisen?
Lordship, that's interconnected.
Or had the demand would not have been there, termination?
Yes, my lord.
Termination would not have been
Indeed,
there?
Indeed. And that's covered in the one
Now,
claim,
once the termination and demand is there, you file the first suit against Indian Airlines.
Only Indian Airlines.
So had that illegal act on the part of the Indian Airlines not being there in its entirety,
Lordship.
be it demand, be it termination,
My lord.
would you have any cause of action against defendant number 1 today?
Yes, my lord.
How?
Your lordship will kindly take up.
Let's see the prayer, defendant number 1 against defendant number 1.
I'm very grateful. That's why I would start with the parties, my lord. I'll come to that. But
Please
kindly
come to the prayer. Come to the prayer.
Yes. Kindly see the first
Notice
prayer.
dated December 22 and January
And 1st February 2006.
Had those notice been there, had those actions not been taken by Indian Airlines?
That's for them to answer because, my lord, today they, my lord, this.
You have filed your claims.
I say they could not have. That's my case. That's my plain case. That today IATA could not do two things. One, IATA could not, and that's what the concession comes from my learned senior friend. IATA could not issue this termination. So they can't blow hot and cold. They've made their submissions today that IATA, this entire sales agency agreement.
I am on a different point, Mr. Bagh.
Well, I'm following.
Had your cause of action in the first suit not being there in its entirety,
my lord,
could you maintain the second suit?
I could. Yes, my lord. For page 52, I'll come to that. Page 52 is the reason why this is an independent proceeding altogether. Can you take up page 52, my lord? This is the termination of passenger sales agreement, agency agreements. Page 68 in your my lord's petition, my lord.
Page 51, page 52.
Your lordship is considering the application.
Yes.
So it's page 68 of the application, my lord. In the plaint, it's page 52. Kindly see who has issued this. IATA defendant number 1.
What is this dated?
Yeah, this is dated 1st of February 2006.
Wait.
Pratham suit ka filing date ta dakho online. But 1st February 2006, Lordship. Wait. 22nd January. আছে ও এটা তো এটা
So this claim,
my lord,
did it not arise?
No, it did not, my lord, because the
out of the agreement mentioned by you in your prayer B to the first plaint at 22?
No, my lord, it did not. I'll indicate why. Can you see the date here once, my lord? 1st of February 2006.
Where?
My lord, the top left-hand corner.
Yes.
At page 68, my lord.
Yes.
Copy file, Lord.
And kindly come to page 22, prayer B.
My lord, before that, my lord, 27th of January 2006 is when my first plaint was filed.
Sir, kindly come to page 22, prayer B.
Page 22 মানে আমার এখানে কোন পেজ আছে?
What is your prayer, sir? Prayer B to your first
notice dated 22nd December 2005.
No, no.
Prayer B, my lord.
Prayer B in the first plaint.
I'm sorry.
Page 22 of the application.
Declaration that clause in the outbound groups of international sectors agreement for the period 15 December 2004 to 14 December 2005 being annexure C, requiring plaintiff to make good the difference between the agreed price and the normal price is illegal, null and void. That's
So
their
had
demand
this
by
agreement,
Indian Airlines.
had this, suppose, let's say, as
My
we
lord.
take a situation,
My lord.
this agreement is not there.
Lordship.
Correct.
My lord.
This agreement is not there.
My lord.
Take a situation
My lord.
as you have prayed for.
Lordship.
Could this letter be there at page 68 of the application?
It's an independent letter, I'll tell you, Lordship,
February
why.
1, 2006.
My lord.
Could it be there had this agreement not been there?
It could be, my lord. Second paragraph. I'll tell you, Lordship, why. My lord, kindly take up the second paragraph. Let me read from the first paragraph. Further to our letter of 22nd December 2005. I'll take your lordship to that letter. We have been advised by BSP India. And who BSP India is, I'll come to that, my lord. That your agency has failed to settle the outstanding by deadline. In this regard, IATA has no alternative but to terminate your passenger sales agency agreement in accordance with resolution 832, section 3, subpara 3.1.2. Termination shall take effect from 1st February 2006. I pause here for a moment.
So this passenger sales
agreement, my lord.
It is dated?
It is. It's dated 15th of December 2005. I'll tell you, Lordship, where I'm getting this. Will you kindly take up a kindly take up page 69 once? All the queries which were, my lord, which fell from your lordship. This is a letter which we have issued against this termination to, my lord, the travel agency commissioner. The regulation, who is IATA, my lord? I asked this question to myself, and my lord, the rhetoric answer is, my lord, IATA is a principal organization. So, my lord, today, out of all the members of IATA, so Indian Airlines is one of the members. Air India, one of the members. My lord, I, as an agent, enter into an agreement with any one of them, all the rules of IATA automatically apply to that arrangement. Once, my lord, there is a specific agreement between me and Air India or Indian Airlines, and there's a fault in that agreement, whatever it be, my lord, it's a termination. There are umbrella rules of IATA which comes into operation. this is what has happened. IATA, there's a separate complaint made by Milord Indian Airlines, and that complaint was made to IATA, whereby Milord IATA was requested that you cancel this arrangement and penalize them separately. That's what has happened. Milord, kindly see the document at page 69. This will make things clear. Milord, kindly, I'll only refer to a few points.
No, I have a very short question. First, you answer that so that it can clarify my thinking.
Whether, Milord, if I've understood the query, Milord, which has fallen from the honorable bench, is this: first suit, I have challenged something. If my challenge to that action, or if that action would not be there, would there be a cause of action for the second suit? That's perhaps the query, Milord. My answer to that very respectfully is yes. Because, Milord, today, the first suit is, Milord, against a party who has, Milord, done a wrong, which has given a cause of action, Milord, to us to file the suit. That's Indian Airlines. Indian Airlines, Milord, has terminated an agreement.
So the reliefs claimed,
my lord, are very different.
In the
Here,
second
my lord,
suit, in the second suit,
could not have been claimed in the first suit. I'll indicate why. That's what has fallen from your lordship. I've understood that, my lord. The reason is this: there are few paragraphs which have not been read. I'll read them, and it will become very, very clear why it could not be. Kindly see who the defendant number 2 in the present proceeding is. This is my cause of action. Insurance company. I have taken the insurance in the name of defendant number 1. Today,
the beneficiary.
Beneficiary. Now, today, if that claim is permitted while a suit is pending against, my lord, Indian Airlines, where why is it, my lord, that the commissioner did not entertain my appellate claim?
Here I am raising my query. Can this,
my lord,
is it not a non-joinder of cause of action in the first suit?
Not, my lord. It is not.
Why not?
I'll tell your lordship. My lord, kindly see
why
all
not?
the prayers that I have made. My lord, I'll tell your lordship. My lord, today, if, my lord, it was connected with the termination, which flows from the termination of Indian Airlines.
That's precisely I'm saying.
That's not what has happened. That's my answer, my lord. Today, if that was the case, I could not have made this submission. What has happened here is completely different. What has happened here, I'll take your lordship to the pleadings once. In my, my lord, in my limited understanding, what I've understood of the pleadings and what's my case, how is it that it is completely different a cause of action? I'll indicate that, my lord. But before that, just to answer the query, my lord, today, if there's an independent action by IATA, it's twofold. One, IATA issues a notice of termination of an arrangement whereby I am not a direct signatory. It's through the umbrella arrangement that a complaint has been made by Indian Airlines to them, not with regard to, my lord, the specific termination which we have challenged as an action, illegal action by Indian Airlines in the previous suit. Here, my lord, the cause of action is different. Here, the cause of action is IATA says I've got a complaint from one of my members who has complained against you. In terms of that complaint, since it's an umbrella body, we have an arrangement with you which need not be through a written agreement with us. It is in general a sales agency agreement. And that is what we are now terminating because there are dues which you have not paid. Separate cause of action, because our case here is to declare that action as illegal and void.
So while trying this second suit,
my lord,
the inquiry is not to be done, required to be done in respect of the cause of action of the first suit.
Very respectfully, no, my lord. The reason is this: my lord, today, if there is no arrangement,
suppose
between
suppose if the cause of action in the first suit had not been there, let's say there is no problem.
First suit, nothing was happening. I am very grateful.
And no first suit and no problem, no issues
with Indian Airlines.
Yes, with Indian Airlines.
Correct. In that event, if, my lord, IATA would have issued this letter of termination, we would have a, my lord, separate cause of action even then.
Against IATA.
Against IATA. Here, my lord, I'm very grateful.
Right.
This is exactly what has happened.
But the moment Indian Airline has terminated an agreement,
my lord,
you have challenged it.
My lord,
the subsequent steps taken by IATA, is it not a fallout of that step?
That's my answer. It is not a fallout of that step because it has been very clearly indicated in the documents which I'll read out that this is an independent action by IATA which we are challenging. We say that you can't take this independent action because there is no arrangement as such by which you can cancel an arrangement. Today, merely because we have signed something with Indian Airlines, whatever is the fate of it, you could not as IATA come and cancel, terminate and raise a demand, which if it remains unpaid, you have an insurance policy to fall back on.
Unpaid consideration,
My lord,
arose where from?
it arose independently from a complaint made by Indian Airlines to IATA.
Bring the copy of the plaint tomorrow.
We will, my lord. But before that, my lord, may I also indicate a few things from the plaint?
Today we have to rise.
Lordship.
Ashwin. Bring it tomorrow.
Lord, tomorrow the difficulty will be, they won't be, my lord, in a position to get it.
No.
May I then come
then
back?
I will have to stay.
No, kindly don't, my lord, because there's no prayer for stay.
No. Either you continue and complete it, or your junior should carry out, or I will have to stay.
My lord, kindly hear me out tomorrow. I'll indicate why. My lord, first of all, this petition, the premise is not a Order 7, Rule 10 or Order 7, Rule 11.
Counsel, I will hear you and conclude the hearing tomorrow.
Very well, my lord, we'll come. My lord,
you come with a copy of the plaint.
Please get it. Somehow get it. My lord.
Ask it from your client over email.
That's what we are, my lord.
Either you have to do or you...
My lord, I am very, my lord, I'll tell your lordship, I'll try and canvass my submissions. Only, I'll bring that, my lord.
Mr. Bagh, I should look at the plaint. It's my
Definitely, my lord, we'll get it. We'll get it, my lord.
So get the plaint. Ashun.
And my lord, I'll also kindly permit me to, my lord, make my submissions from this plaint.
Of course you will.
I'll tell your lordship one before
my lord. Require now, today. You make your submission as long as you want. Make your submissions. I don't
Only for this reason, my lord, a lot of submission has been made with regard to agreements. And Ambalal Sarabhai, paragraph 13-14 has been shown.
You will come up.
Deal with it.
Make your submission.
Only that.
But I want to see the plaint tomorrow. And you have to continue tomorrow. Even if you start, your junior will continue. Ashwin.
Because nothing to do with an agreement what I'm relying on. I'll show that.
It's
Tell him to bring it immediately.
This is an application.
I want it. I want to see it.
Filed by the defendant number 1, in effect, to convert the instant commercial suit, to reconvert the instant commercial suit to a general suit. Though it has previously been converted from a general suit to commercial suit. Paragraph. Mr. Anirban Ray, learned senior advocate. No, MS. Shormi Dotto, learned counsel, led by Mr. Anirban Ray, learned senior counsel, and Mr. Siddhartha Banerjee, learned senior learned advocate. Appearing for the defendant number 1, have completed their submissions. Paragraph. Mr. Pronit Bagh, learned counsel appearing for the plaintiff, has commenced his submissions, he shall continue tomorrow. And he shall continue with the same tomorrow. He shall continue tomorrow. Paragraph. Immediately after completion of the submission of Mr. Bagh, the learned counsel for the defendant number 1 shall reply thereto. Paragraph. The plaintiff shall produce a copy of the complete set of the plaint filed by his client in, what's that number, CS? CS 23 of 2006.
23 of 2006.
CS 23 of 2006 tomorrow for perusal of the court. Paragraph. The matter shall appear under the heading for orders tomorrow. तारीख दिए दो.
Would it be my lord's pleasure also, my lord, to call for production of, my lord, that?
Not required. They shall produce. अच्छा उठाओ तो लिखे रखो. In any event, the original plaint in CS number
23 of
2006 shall be produced before this court tomorrow by the department concerned.
I'm very deeply prepared.
My lord, may I have a
ठीक है.
liberty, my lord, to inspect in case, my lord, the records arrive. My lord, before my lord sits, my lord, may I have a liberty, my lord, to just inspect, my lord, the plaint once, if provided, my lord, the plaint arrives.
Let's see. I will give you if
Wait,
necessary.
wait, because we are not parties there.
Let's see.
Wait.
Thank you.
Very
Grateful,
deeply prepared.
grateful,
Very deeply.
grateful.
Because if I discontinue the hearing,
I understand.
I will forget and unnecessarily